Okay, thank you. Okay, well, welcome members. We're now in public session. Just to remind you that we're being broadcast online and throughout Parliament building. So just want to welcome Claire joining us online today and those who are watching. So if you can remember to mute your mobile phone and that no recording nor photography of the meeting is allowed. So I'm going to proceed with the agenda. So we have apologies from Carol, and I think we're waiting Sinead coming online, but we'll proceed. Any declarations of interest to declare? Okay, so Chairperson's business. The first one is item 3.1. The Irish Language Commissioner. I'm going to refer you to pages 6 to 8 of the pack. And just to advise that the committee has received correspondence from the Irish Language Commissioner regarding his previous correspondence to the committee dated 30th of April 2026. The Commissioner is asking the committee to look into how a copy of his correspondence to the committee was subsequently published on social media by Mr Jamie Bryson on the 11th of May 2026. So just to advise that the Assembly's privacy notice sets out how Assembly committees process and protect personal data collected from individuals or provided to committees. The notice makes clear that committees recognise the importance of protecting and respecting individual privacy and data rights, and that personal data may be processed in order to support committees in carrying out their statutory functions. Committee correspondence is retained in line with the Assembly's retention and disposal schedule. Correspondence other than evidence is not routinely published, either on the committee's website or as an appendix to any committee report. However, a committee may decide to publish correspondence as part of performing tasks in the public interest. These tasks include committees' statutory scrutiny function and their role in the promotion of democratic engagement. However, the correspondence the Commissioner refers to was not published by the committee. So just to advise that in relation to the specific issue raised, the committee does not have any evidence to demonstrate how this correspondence came to be published externally. As such, it is not in a position to comment on any disclosure. And just to remind you all of the importance of handling correspondence in accordance with the Assembly policies. So I'm going to seek your agreement to respond to the Commissioner outlining the above, and to advise that if he is unhappy with any aspect of the committee's privacy notice or how their personal information is being processed, to contact the Data Protection and Governance Officer. Are we content?
Yeah.
Okay, go ahead please.
Yeah, if I could just say a couple of quick comments on that, and if it makes Mr Deeds feel better or get to the bottom of this, I think we should indeed contact Mr Bryson and ask for his comments on the issue to see how he got the correspondence referred to, because I think that's the proper due diligence that this committee should do, regardless of who the complaint or the query has come from. But just when we're on FOI, and I was going to raise this as a later on than any other business, for one of our arm's length bodies, what stipulation is there on setting up, when they set up meetings with the likes of BBC NI and their hierarchy, what stipulations or what framework do they work to regarding recording those meetings, any minutes they take? Because from FOI material I've got from Mr Deeds, he sought a meeting with the head of BBC NI, Mr Adam Smith, and we can see in the correspondence that he sought the meeting, he had the meeting, but there's no minutes or a record of what the outcomes were, and that's why I'm wanting to know what stipulation, what safeguards are in place for commissioners, that when they have these meetings, that we can see what they've discussed. Like, let's get to the crux of the matter. Essentially, is that this is the man who suggested that criticising the Irish language was unlawful. He's also attacked the credibility of a very well-established journalist by claiming the translation was poor. So I would be very keen to learn that Mr Deeds has been exerting pressure on the BBC to ensure that his narrative is receiving unnecessary support, or if he is trying to frame and shape BBC NI policy, that we'll be able to see what that is. So I'd be keen that if there's a bit of work done on what minutes that commissioners, and I'm not just talking about one commissioner, all commissioners are meant to take when they're holding key meetings, such as meeting with media outlets.
Okay, so we can write to the department. Are people content? We would write to the department and ask for that. Okay, going to move on then. So, sorry please.
Are we going to write to Mr Bryson as well?
Do people...
It's up to the committee, but I wouldn't want Mr Deeds thinking that we weren't taking this seriously.
So from my perspective, Chair, we don't have any information as to why or how it got into the public domain. Not that I think he sent us the email in restricted or anything like that, but ultimately it's not a matter for the committee, so
Yeah. I think
he
that-
may wish to take it up with the other avenue, but it's not a role for us to get involved in.
Okay.
Have we enough?
Okay. Okay, so 3.2, the NIPSO launch event. So this morning I attended this event, was invited to as chair of this committee. It was in relation to their new model complaints handling procedures. I'm not sure anybody was on the committee in 2021, but this committee brought forward a statutory rule to enact Section 3 of the Public Ombudsman's Office Act. It was something that they were looking for, and I think this committee responded very positively and expediently, so I think that's why they wanted to be there today. Okay, so draft minutes then. So just to inform, the draft minutes of the meetings held on Tuesday the 16th of June and Wednesday the 17th of June are at pages 10 to 24 of the pack. Just going to ask our members' consent that these minutes are a true reflection of the proceedings of both of these meetings.
Great.
Okay, so matters arising 5.1 to 5.6 draft framework for race relations and delivery plan 2026 to 28. I'm going to refer you to pages 26 to 54 of your pack, and just to advise that following the stakeholder panel sessions held at the meeting on the 27th of May this year, a draft response on behalf of the committee to the draft framework for race relations and delivery plan was compiled by the clerk. An updated draft response can be found on pages 28 to 38 of the pack to reflect additional views and or comments by members of this committee. So feedback was submitted by members, and this can be found on pages 50 to 54 of the pack. So just to advise that the response to the departmental consultation from the Law Centre and I is also included for information at pages 39 to 49 of the pack. So are members content with that submission as amended by the clerk? Yeah, okay.
Chair, just on that, so what is the next step? So there's a couple of queries that are still outstanding. Indeed, HMOs, I think Deborah had raised when witnesses came before us. What we see is that what is being submitted. So it's not essentially coming from committee, it's more individualised members and what the witnesses have said.
Indeed, yes. Through the chair. There is correspondence later on today on the agenda from Hiding Rights and I in relation to your query. They've provided a written briefing paper, and we'll also include that with the letter that goes out.
That'll be part of what's submitted.
Yeah, and we're also we're waiting back a couple of other pieces. I think it was yourself had raised when we're chasing that up with the
And once
officials.
that comes, will that be updated further to contain?
We can forward it on for
Yeah.
inclusion with that paper.
Okay, thank you. Okay, so seek your agreement then to forward this response to the department. Agreed?
Right.
Okay, 5.7 to 5.9 race relations potential committee engagement. Just going to refer you to pages 55 to 57 of the pack. And just a reminder, at our meeting on the Wednesday the 10th of June, members agreed that the committee team should explore the feasibility of hosting roundtable meetings and events for those most affected in relation to the Executive Office initiatives and strategies. So just to advise that there's only one remaining meeting before summer recess after today, and there's no availability in the Long Gallery to facilitate the holding of roundtable events. In addition, arrests have been made and charges have been brought, therefore the matter is considered sub judice. This restricts the committee's ability to discuss the issues in a public forum in detail. So just to remind that the committee has agreed to write to the First and Deputy First Minister on the matter. However, no response has been received. During question time on Monday, the First Minister outlined that they had met with members of the Racial Equality Subgroup to hear about how the disorder has impacted people and their communities. The First Minister also outlined that they have met with council hubs and reinstated the crisis funds and have released funding of £400,000 for the planned intervention programme, which is engaging 1,400 young people. So just to advise, given the issues of sub judice and limited availability before the committee breaks for some recess, members are asked to consider the following potential actions. One, ask the Executive Office officials in the Race Relations Unit to provide an urgent written or oral briefing to the committee on the actions being taken by the department, including any follow-up actions for TO following the meeting with the Racial Equality Subgroup, and to request further details on the planned intervention programme. Second option is to consider the possibility of holding roundtable events with stakeholders in the next session, which would be September to December, following publication of the first annual report on the refugee integration strategy, and a copy of the strategy and delivery framework can be found on pages 58 to 91 of the pack, and or write to 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 request details of the membership of the 4 governance structure groups, and to consider the membership as a starting point for potential roundtable engagement following publication of the first report of the refugee integration strategy. 2 more actions, potential actions. Write to the PSNI to seek an update on the incidents, community impact and any preventative or support measures being taken, while again respecting sub judice constraints and any contingency plans in place should further disorder arise over the summer. And lastly, defer any further committee consideration of these matters until after summer recess, when more comprehensive engagement may be facilitated. So any thoughts on those?
Sure.
Go ahead, please.
If I may, I think it probably would be at the late stage that we're in at the minute, just before summer recess, if we write to the PSNA just to seek an update from them, most importantly on what contingency planning they're looking at. I'm not saying I hope there's no trouble over the summer months, but just to see what plans they're putting in place, and then maybe come back to this in September.
Okay, I think some of the other stuff there as well would be useful for us, maybe just to get the letters off, and that would be the first one there, TO officials in the race relations issue in terms of what they're doing with follow-up, racial equality subgroup, and then also the the engagement around the 4 governance structure groups, and then there's another one there about the funding, the planned intervention programmes. So, and we will wait and have a look at the stakeholder sessions in the autumn. Is that okay? Go ahead, please.
Sorry, Chair. Happy enough to, in terms of that, just something I wanted to check out in relation to when we're writing to the First and Deputy First Minister in relation to it, and it's in 7.8, which I think is one of the strategies there that we have. Yeah, the refugee integration strategy on page 73. Can we just check out in terms of, we have asked for this I think before anyway, but it talks about the liaison between TO and the Home Office and the data that is available to them. So I'd be interested to find out in terms of that data what we're actually receiving back. And then it says that that's shared across departments, local councils and agencies and stakeholders, but it says as appropriate. What's deemed as appropriate when that data is actually shared with those bodies, because I think that's sometimes at the heart of the issue is around the data and checks and things like that there as to why some of this, riots and things like that happen as well. So it'd be interesting to see the cold hard data and the facts of what we actually receive here.
Okay, no, that's fine. I did ask the First Minister when we will see the annual report, and it's been pulled together, but hopefully we'll get that in for early meetings in September. Okay, I'm going to move on then. 5.10 to you, Violence Against Women and Girls funding. I'm going to refer you to pages 92 to 120 of your pack, and just a reminder, at last week's meeting the committee agreed to consider the aspects of funding across TO, including the local and regional change funds, and whether such funding would be more effectively allocated to the Departments of Education and Justice as part of our potential inquiry into any violence against women and girls. Is that my brain, aren't it? So just to advise that the committee team has asked RAISE to be aware of the above, and that they would include this in their briefing to the committee at next week's meeting on the scoping paper for our inquiry. Did you want to go ahead?
Yeah, a couple of things. When I was looking through this again, the Derry City and Strabane District Council, I was very interested in that there's 1, 2, 3, 4, 5, 6. There's 8 DEAs that they have, and they've awarded them £8,000 each. Obviously doing work internally, and I think that probably is a very good use of the money because council have it under their control. I'd be interested to hear back from the council what benefits this has brought to each of the DEAs, and as well as that, it's something that's been rolled out throughout the entirety of the council areas. So that's something I would like to learn more on. And just going back to the Mid and East Antrim, I don't want to pick on them too much, but there's two organisations that have received funding within their pool. If you look across the different council areas, they keep coming up in different councils for different projects. Very, very good projects are running, but I do believe that they should be funded through the Regional Change Fund and not through the local one, because it's taken away from money being spent in that area.
Yes.
And if you look at Fermanagh and Omagh, who have spent considerably less than some of the rest of the councils, is it a case of the council should be reducing the funding they get, and maybe look at more using the model more so like Derry and Strabane have done by funding each of the DEAs and getting the council to work within the DEA officers, instead of funding organisations which are clearly coming in under local change fund from a number of different councils, where I believe they should be doing a Northern Ireland wide campaign and doing some of the things like, don't want to mention them by name, but it talks about education to year 7 pupils and up to 60 schools. So why should the Mid and East Antrim money be used for something that's obviously going across all of Northern Ireland?
Yeah, no, I agree, and I think that's really cuts to the heart of why we are going to have our inquiry, is to see whether the money's been well spent and where there's really good practice and where we're not sure about the actual impact. So, no, thank you for that. Was there any actions out of that, Clark?
Right to them.
Just that we write to them. Do we want to widen it out to write to all councils?
I actually think, like, as probably as part of that inquiry, we
Yeah.
probably should be inviting the
councils
councils
to
to that.
Or make a
Anyway,
specific
because
response?
I think, you know, obviously they're administering some of this grant
Local
aid
change
going
fund.
out. So I think in any event, I think all the councils, we should hear back from them just to see how it is impacting in the areas, and whether that DEA type model should be something that the other councils should look at, or whether we're seeing the benefits are better because a localised group are using it. So I think it's something to scope out maybe for them.
How they decided, so
Yeah.
we're going to allocate.
Yeah.
But the assistant clerk just reminded me there that we said as part of our inquiry we would have some roundtable discussions upstairs
Yeah.
with some of the recipients of the local change fund grants, for them to sort of speak to that as well. But I do take your point around the sort of civic leadership in the councils and how they reach that decision.
Yeah.
Go
I
ahead.
was going to say, yes, I'm fascinated to know how Derry and Strabane have decided that that money should be split between the DEAs, because I can think of other council areas where the numbers of people in DEAs and the sort of challenging work that you'd be doing would be very different. Some DEAs will really not have any particular areas of concern. Some of it might, and of course as Timothy said, some of it will be spent in schools, but that really should be done centrally through the Department of Education rather than through this funding. So I think, yes, you're right, Chair. The round table will be the opportunity to pull a lot of this together. It might be useful actually to send some sort of questionnaire out in advance to local councils and ask them how. Yeah, and I think more importantly, it's not just how they decided to distribute the money, but actually the impact assessment of what the feedback is in terms of delivery.
Thank you.
And just one final point for anybody listening on, that the Derry City and Strabane, it was 25% roughly their funding they allocated internally to the DEAs, and the rest was external, just in case somebody thought that it was all.
Yeah.
No,
There is some very good projects that they do fund through that, but it's a case of there's 25% that's been allocated to DEAs, and I do like the thought of the council taking ownership of that and rolling out a programme right across the council area.
Okay. Moving on then, 5.11, Phoenix Law, Minority Ethnic Support, Armagh. So I'm going to refer you to pages 121 to 125 of the pack. Just a reminder that the committee wrote to Minority Ethnic Support Armagh on the 11th of June 2026 to invite Ms Fearon to return to the committee to continue the conversation in relation to the race relations framework and to reflect on the comments made in relation to Mr Gaston. So just to advise that the committee has now received a formal response from Phoenix Law, acting on behalf of Ms Fearon. The correspondence outlines that Ms Fearon respectfully declines the committee's request to return to continue these discussions and to reflect on her comments. Full details of the position are set out in the correspondence, and Minority Ethnic Support Armagh as an organisation has approved the contents of this response. So I'm going to seek your agreement to note this item. Do you want in, Philip?
Yeah. First of all, I just want to express my surprise at the correspondence, because on the 1st of June, Minority and Ethnic Support Armagh sent us a letter from Peter Wilkinson, who was deemed as operations. However, having had a brief look at their business accounts from last year, he's actually their chairperson. But at the end of that letter, purporting to be on behalf of the individual, stated, I therefore wish to place on record my sincere apology for the language used and my continued commitment to respectful and constructive engagement on these important issues. So I was then very surprised, hadn't claimed to the committee in her letter to us that she looked forward to respectful and constructive engagement, that she then went and sent a solicitor's letter to the to this committee. I do have a number of concerns about it. Firstly, the letter that we sent was to Minority Ethnic Support Armagh, not to Fidelma Fearon, so I don't believe that this is a response on behalf of the correspondence that we sent. I'm also interested to know if the Minority Ethnic Support Armagh group paid for this legal advice and legal letter, because according to the business accounts I referred to earlier, the Executive Office provides £46,000 a year to this organisation, so I'd be concerned to know whether public money was used to provide, which is essentially a private legal matter that Fidelma has decided to go down. So even the contents of it, at no point did anyone on this committee refer to compellability or trying to compel Fidelma to come back. So I find it strange that she went on to say you then went to set out the legal status in their view in relation to their committee. She was simply asked, does she want to come back to this committee and apologise for her remarks? Clearly she doesn't want to do that, that's fine, but I do think that the correspondence raised further questions, because this committee wrote to Support Armagh, not to Ms Fearon in an individual capacity, which clearly this legal letter has been received from.
Okay, before I bring Timothy in, so I did raise the issue about the compellability in mine, and I said that I was comfortable with inviting her back to reflect, etc. But that I if it started to get into this space where we would be seeking legal advice, for example, then I think we've gone too far with enough other business. So it was possibly my commentary in the meeting, so I refer to some conversation we'd had earlier at the pre-brief around what that actually means. So I think that's where that came from. Go ahead, please, Timothy.
Yeah, following on from Philip's train of thought, obviously we've got the solicitor's letter. No apology, whereas previously when we had the letter from Peter from Operations, there was an apology on Fidelma's behalf, according to the letter. I think members were right to question the validity of and the sincerity of the apology when we indeed have received this. This is a body that is in receipt of significant amounts of public funding. I estimate alone from what's available in their accounts that over a 5-year period it could be up to £225,000. They also receive funding from the Department of Health, Housing Executive, ABC Council, and to turn around and treat this committee with the contempt in which they have. We sent a letter to the organisation, and the organisation has approved a letter coming back to us from a solicitor. That shows a complete breakdown and a complete disregard. The only shining light in it is that they're keeping an eye on the TUV social media channels, which I'm glad to see that they're keeping an eye on what's happening. But I certainly wouldn't be happy, and this is an opportunity for the committee to show its teeth, to show that when somebody comes, regardless of the person, if their members are being disrespected, that the committee does something about it, and they simply note this and move on means that the committee has shown that it has no teeth. It will continue to be treated with contempt from witnesses that maybe there has been direction given to, but you cannot escape the fact that this organisation is in receipt of huge amounts of public funding, and they're basically turning around and saying, well, we're not going to engage Fidelma, you send a solicitor's letter, we'll agree to it. I don't think that's the right way to conduct business. I think it's pretty poor on behalf of the organisation, and I wouldn't take this as a response from the organisation, because it's clear in the letter that this is from Fidelma personally and not from the organisation. So I do believe that there is further correspondence should be sent to Minority Ethnic Support in Armagh, looking for a response to the original question, or the letter that you sent, Chair, on the 11th of June. Yes, absolutely. There is no contempt of the Assembly, but under Section 44, this committee, I believe, has the powers to compel any witness, and they are essentially riding roughshod over that, and completely disregarding the will of this committee. So, no apology. That's quite clear. I believe there won't be an apology coming from him, but it leaves a very sour taste in the mouth of how minority ethnic support and Armagh have treated this committee and how they don't respect the views of it.
Okay, Deborah, please.
Yeah, I would agree actually on that because, I mean, they are a group that we would potentially want to hear in other aspects, and they potentially would be a group that would come back again to this committee. And I'm quite disgusted in ways that they have treated the committee and members of the committee in the way that they have. I mean, looking at the letter that was sent, it said, on review of the video footage of the session, our client's evidence had concluded. They were still here at this committee and called someone a bastard at this committee. Despite the fact that the evidence session may have concluded, that was caught on recording. And I don't think it is right that we should allow that. You may disagree with people in their political views. I disagree with many people on their political views. I meet people every day of the week that I disagree with on their political views. I don't use that language in meetings, certainly not towards people. And I think that we should send a message that, you know, you cannot disrespect people regardless of their political views. So I would tend to agree that, you know, I think we should show some teeth, to use your phrase, Timothy, on this, that you know, it wasn't right what happened regardless of who it was in this committee, and I'm disappointed as well that there hasn't been that apology directly from the person that committed that in this committee as well.
Okay, sorry, just see if anybody else wants to come in. Anybody online? I suppose the other aspect of what I spoke on that 10th of June meeting, so I said that following conversation with Trevor in his capacity as clerk, he had said that, was it once before? Do you want to maybe repeat that?
Yeah, it was quite some time ago. Public Accounts Committee did use Section 44. It's quite a long, drawn-out process, and you have to give the witnesses the information in advance about what you're going to ask them and the lines of question that you're going to go down. And essentially, when they do come along to committee, they are only obligated to respond to those particular questions. So it can be, you know, I suppose, need to be care taken how you actually phrase the questions and the information that you're providing to the individual in advance, so that you get the most out of the actual session itself.
Yeah. Look, from my point of view, I'm bringing in a second, Timothy. From my point of view, it was wrong. It was disrespectful, and I said this personally to you and publicly. It was wrong, and I think that she, in her own capacity and within her organisation, will have learned a lesson from this. Like, I'm sure that mistake or that comment wouldn't be made again in this building. But I think that we have only got, once we're back from summer recess, we only have a number of months, and is this something that we want to expend a lot of committee time on when we come back after the summer? And I think that it's, from my point of view, it's not. Go ahead, Timothy.
So just to be clear, when the invite came out from the committee, it was to the Minority Ethnic Support Armagh to come and give evidence. So it was the organisation then appointed Fidelma to come here. So I think the Minority Ethnic Support has to take some responsibility over this situation, because they were the ones that sent Fidelma, and to receive a letter back from a solicitor acting on behalf of Fidelma and not on behalf of them, I still believe they haven't completed their role in responding to our correspondence, because we sent it to them, we didn't send it to the individual, and we need to be very clear that they as an organisation need to have ownership and take ownership of this.
Go ahead, Clark.
For the chair, if we write to the organisation in the strongest terms of what's been laid out today, ask for their comment on that and see if they give us the results that the committee wants, and if not, we could then pursue other avenues.
Look, I would prefer to draw a line under this. I fully understand how disrespectful and how disrespected you felt, Timothy, but I'm just not sure what we're actually going to glean out of this.
But it seemed it's not about feeling disrespected. It's the committee being disrespected that we have sent correspondence and get a solicitor back from an individual instead of from the organisation.
So from my perspective, I'm keen to see, is this the official position of the ethnic minority, because it stands in stark contrast to what Peter from Operations sent the last time. And if that is, fair enough, but I'm also keen, was any public money used to employ this solicitor on behalf of a private matter? If they come back and say this is their set position, then I will probably follow up with them in a private capacity and highlight to their funders that this is how they've engaged. But from a committee perspective, I think we simply ask, is this your settled position? Did you use public money to pay for it? And then that's probably the end of the road from this perspective.
Okay, well, I think that's a compromise then. Are people content with that?
Yep.
Okay.
You chop the letter and clear
Yes,
it
please.
yourself.
Thank you. Okay, moving on then, we're still under matters arising. So 5.12 to 5.14, so further consideration stage of the inquiry and redress scheme bill. So just wanted to start off by thanking the committee team for their work in preparing us for that, the amendment, and obviously Stephen Orme in the Bills office as well. It was a really good debate and a really good outcome, so thank you. Just want to put that on record. So just to advise, ordinarily Trevor would be required to excuse himself for the next item due to potential conflicts of interest, but given that the final consideration stage just passed and the only final stage remains of the bill, with members' agreement, Trevor will remain in this meeting for this short item of business. Right? Okay, so just to advise that a copy of the annotated marshalled list and minutes of proceedings from the further consideration stage debate on Monday evening can be found on pages 3 to 8 of the table pack. As members will be aware, the committee's amendment to change the posthumous date from the 29th of September 2011 to the 28th of April 1953 was made by the House. So just to remind that the committee received a response from the department to its correspondence of the 16th of June 2026 regarding the amendments previously tabled by Mr Jerry Carroll and can be found on pages 9 to 14 of the table pack. This was also emailed to members on Monday ahead of the debate. And just to remind that the final stage of the bill will take place on Tuesday the 30th of June 2026 and the indicative timings are from 1:30 p.m. to 2 and then after question time. Survivors and victims will be attending Parliament buildings and further details will be shared once arrangements have been finalised with the department. So does anyone want to make any comments or are they content to note?
Sure, just to pay tribute to you and the work that you've done on this. Thank you.
Thank you. Go ahead.
Yeah, very much agree with all the comments that have been made, and one thing I just would like to highlight Stephen Orme when he sent out the correspondence on Monday which set out the order of debate. I haven't seen that for any other bill that has come before, but he has done that for consideration stage and further consideration stage, what I thought was very, very helpful. It gave members the opportunity to be able to follow it, work down through it. And I would like to, as well as his work he's done and given us advice, I would also like to put on record that I think that's a very good tool that is created, and hopefully other ones will follow suit for other bills.
Hopefully they'll be listening. Members, with your agreement, can we go into closed session for 1 minute? I just wanted to raise an issue. Thank you.
Committee Room 30. Sound. Committee Room 30. Sound. Committee Room 30. Sound. Committee Room 30. Sound. Committee Room 30. Sound.
Okay, thank you. Okay, members, we're just going to move on then to 5.15, First and Deputy First Minister oral briefing. Just going to refer you to pages 15 to 16 of the table pack. And just to advise that the First and Deputy First Minister wrote to the committee advising that they cannot attend the scheduled oral briefing with the committee at next week's meeting due to diary availability. So I'm going to seek anybody's views or comments on this. Go ahead,
I mean, a
please.
quick one. So, in the correspondence, it talks about thank you for your recent correspondence from the committee chair. When did we send the invite to ask them to come along? Like, essentially, they have kept us stringing along for which I see a number of weeks, potentially months, whether they're coming or whether they aren't. We do need to get to a position where it agreed how many times a year we're going to invite them. I believe it's been left to the very last committee meeting, and they've just said, you know what, we'll disregard that, we'll not go. It's not the first time we have been cancelled at the last minute. So I think when we come back, there needs to be a clear timetable of dates put in. These are the dates that we are requesting to come before committee, and if they can't make a Wednesday afternoon, following on from what the economy committee do, they hold additional meetings with the minister. When you see what has happened with Fidelma, when you look now that the First and Deputy First Minister who are responsible to this committee, we're meant to scrutinise them, have turned around a week before they're meant to come here and said, oh, we have diary commitments, we can't go. I think it looks poor upon this committee, no reflection of anybody in the room, but it looks poor upon how they view the seriousness of this committee, that they should be responsible to us. And indeed, on that basis, we need to ensure that before we break for summer recess, that they are very clear of the dates we ask them to come along. And if we need to arrange special meetings, whatever we need to do that as quickly as possible.
Okay, so do you want to highlight when the correspondence or the invite went?
You've got the dates?
Thank you.
So Timothy, we initially wrote to them on the 13th of April, then the 10th of June and the 18th of June. So 3 separate occasions.
And this is the first time they've replied.
Yes, that response was received, sorry Chair, at 10:10 last night.
Last night. Okay.
Chair,
Sorry.
can I just come in here
Please go ahead. Yes.
quickly? I wasn't surprised at all when I seen it.
No.
I mean, it's the modus operandi of this of the First and Deputy First Minister. It's constant. This committee has been disrespected on so many occasions now that you just almost expect it to happen. On all occasions that you actually invite them to sit before this committee, it's beyond ridiculous now. It's disrespectful, and I think that is a really serious position for us as a committee to be in, where we can't even scrutinise the leadership of the executive.
Totally agree. Okay, so I've a couple of potential actions here that the committee team have provided, but I've got one of my own as well. So to write to the First and Deputy First Minister to place on record this committee's disappointment at their inability to attend at 1 week's notice, particularly given that the date was first proposed to ministers in April, and request that every effort is now made to facilitate the rescheduling of this evidence session, that this session should take place at the earliest possible opportunity, and members are prepared to consider dates, as Timothy's just suggested there, during the forthcoming recess period or on a different day. But what I want to know is, what is more important? Like, when is the last time they were before us? February. And so I want to know, can we get access to their diaries?
When that diary entry was filled,
Yeah.
if it was after this committee had
Like,
requested
what
them
are
to
they
come.
doing that is more important than holding themselves accountable as government ministers to their relevant scrutiny committee? So can we see if there's a procedure in that? I think maybe it's FOIable, but I would think we would try and short circuit that process, but if not, I think that's possibly a way we would go down, unfortunately. Go ahead, Deputy Chair.
I think internally, I was going to say informally, internally we should be able to request sight of the diary, and just to simply know and understand the timing around that. And if memory serves me right, the Deputy First Minister on the last occasion took herself off to Wimbledon, but that was the excuse we were given.
So, okay, go ahead, please.
I can just provide some update as to where the Deputy First Minister is next Wednesday, the 1st of July is the 110th anniversary of the Battle of the Somme. And the Deputy First Minister will be representing the Northern Ireland Executive at those important commemorations.
You want to?
That was exactly what I was going to say.
yeah.
But I think just if you don't mind, like I know whenever I'm organising meetings, if I can't make a meeting, I would come back and say can't make it, but here's other
Exactly.
dates that I
Yeah.
would be available. So I suppose that could be reflected as well.
We need to get a date from the MESOP.
Yeah.
Like this date will have been known for months.
Yeah.
This
Yeah.
invite will have come in months ago, and even just the disrespect to the committee team who's been trying to, in particular the assistant clerk who does the board work programme. So
Could have been today rather than next week.
could have been today. Okay, we content then to write back in that regard and ask for their diary.
Yeah.
So. Okay, members, moving on to our first oral briefing today with the Equality Commission in relation to the Supreme Court judgment in For Women Scotland Limited against the Scottish ministers. And I'm going to seek your agreement for Hansard to record this oral evidence session. Great, thank you. Okay, members, just to remind that the committee previously agreed to seek legal advice on suggested areas of questioning ahead of the oral evidence session with the Equality Commission. Legal advice has now been received, and members are further reminded that any discussion on the contents of this advice should be held in closed session. So if anybody wants to discuss this, we can move into closed session, or are people content?
Right, yeah.
Okay, it's going to refer you to pages 127 to 130 of the pack for the clerk's brief, pages 131 to 142 of the pack for the written briefing from the Equality Commission, pages 143 to 155 of the pack for a copy of the UK Supreme Court case summary, and pages 16 to 22 of the tabled pack for the legal advice on the proposed questions from Assembly Legal Services. Okay, so welcoming to the meeting we will have Miss Geraldine McGahey, OBE, who is the Chief Commissioner of the Equality Commission for Northern Ireland, Ms Louise Conlon, who's the Chief Executive, and Mr Neil Anderson, who's the Deputy Chief Commissioner. So thank you very much for coming to committee, and I would invite you to make some opening remarks.
Okay. Thank you, Chair and members of the committee. Good afternoon, and it's our pleasure to be here today to answer your questions. You'll see I'm joined by Neil Anderson, who is our Deputy Chief Commissioner and Chair of our Audit and Risk Committee, and Louise Conlon, who is our Chief Executive. As you noted, we have already provided the committee with a written briefing setting out the background and the legal context and the steps the Commission has taken following the Supreme Court judgment in For Women Scotland, including our consideration of the more recent Dillon judgment. I do not intend to repeat this information in my introductory words, but of course we're happy to take any questions you might have it as we progress. But I want to be really clear from the outset. The Commission is not challenging the judgment of the Supreme Court in For Women Scotland, which was an important judgment. We have repeatedly stated in unambiguous terms that were it not for the Government's commitment under Article 2 of the Windsor Framework, courts and tribunals in Northern Ireland would and should deem the judgment in For Women Scotland as highly persuasive in respect of interpreting terms such as sex, men and women in Northern Ireland equality law. Immediately following the handing down of the judgment, the Commission received queries regarding a potential breach of Article 2 of the Windsor Framework. And as required under our duties, legal advices were obtained, which consequently highlighted significant uncertainties in respect of the legal framework, and therefore work on the development of guidance that we already had underway was suspended pending the necessary clarification. However, the legal reality is that Article 2 of the Windsor Framework does exist and has potential legal significance in Northern Ireland, a matter incidentally that was affirmed in Dillon. The Supreme Court in For Women Scotland did not consider Article 2 in its judgment because it is not relevant to the interpretation of the separate equality laws that exist in Great Britain. The Commission, this Assembly and the Northern Ireland courts simply cannot disregard obligations or potential obligations that exist within the Northern Ireland legal framework. We have carefully considered how best to fulfil our responsibilities in this area. Asking the court for clarity is not a step we have taken lightly, but ultimately only the courts can provide a definitive interpretation of how these legal provisions apply in Northern Ireland. The Commission has a statutory responsibility to consider all relevant issues and seek clarity so that any guidance we issue is workable, accurate and robust. In our legal paper and formal application to the court, we asked that the proceedings be stayed until after the judgment in Dillon was handed down, as it would be key to addressing some of the legal uncertainties around Article 2 of the Windsor Framework. The Supreme Court issued its judgment in May of this year, and as anticipated, it provided important clarification concerning civil rights. It also confirmed that Article 2 is capable of having enforceable legal effects in Northern Ireland in certain circumstances, one of which was expressly confirmed to be where the Annex 1 directives apply. And this is particularly relevant to our For Women Scotland roadmap because it invokes the anti-discrimination provisions of some of those directives. However, Dillon did not resolve all of the questions relevant to the Commission's application. The question of whether EU directives, as interpreted by the Court of Justice of the EU, require Northern Ireland equality law to have different meanings for words like sex, man and woman, compared with Great Britain equality laws, very much remains live. As we stated before, the Commission cannot ignore the obligations or potential obligations that flow from this. Following Dillon, there remain three important questions regarding the Annex 1 directives. What the relationship is between the bullet point rights set out in the Rights, Safeguards and Equality of Opportunity chapter of the Good Friday Agreement and the Annex 1 directives. If the Annex 1 directives must fall within the ambit of one of the bullet points, what is the scope of those rights and do they extend beyond biological sex? And if the Annex 1 directives must fall within the ambit of one of the bullet points, can they only have direct effect if they are concerned with ending sectarian violence and conflict? As set out in our briefing paper, we are asking the Court to consider the issues we have raised in a structured and cascading way. We believe this approach ensures the Court not only considers the questions it needs to answer, and that judicial resources and costs are managed as efficiently as possible. I have to say that taking legal advice, taking legal action, is not something the Commission does lightly. We considered all of the options available to us and concluded that seeking clarity from the Court was the most responsible course of action. The Commission is already facing two related judicial review applications that raise similar questions, albeit from two very different perspectives, one from the Good Law Project and the other from the Women's Right Network. This demonstrates the complexity of the issues involved and that the risk of additional litigation is very real. We recognise that this decision has attracted criticism. The Commission has faced calls for resignations and claims that we are acting as activists. I can assure you all, I am no activist, nor are my fellow commissioners, and indeed neither are staff colleagues. We are simply doing our job and working in good faith to produce legally robust and workable guidance that stakeholders can rely upon. Our decisions are based on our statutory duties and the legal framework that applies in Northern Ireland. Without legal clarity, there is a significant risk of continued uncertainty, further litigation, and employers, service providers and public authorities being left to navigate these complex issues and questions themselves. I want to conclude by reiterating the Commission is not challenging the Supreme Court judgment in For Women Scotland. We recognise the importance of that judgment. Our role is simply to understand how it applies within Northern Ireland's own legal framework, including the commitments under Article 2 of the Windsor Framework. We are seeking clarity so that we can fulfil those responsibilities placed on us by law and provide guidance that is accurate, workable, and gives confidence to those who need to apply it. Whatever the outcome of this process, the Commission's focus remains on ensuring that equality law is understood and applied and that everyone in Northern Ireland is treated with dignity and respect. And thank you for the opportunity to say those opening words. Thank you for listening, and we're happy to take your questions.
Okay, thank you very much, Geraldine. So just before we open for questions then, just to advise members that given the ongoing legal cases, it may be that the Equality Commission delegation are not in a position to answer all of the questions from members today, nor to delve into the level of detail that might ordinarily be the case. So go ahead, we'll ask our questions, the clerk's going to time then, so we can all have an equal amount of questioning time, but if we can show respect and accept that witnesses will answer questions as fully as possible, okay?
How long do we have, Chair?
Probably about 8, it's usually about 8 minutes, isn't it?
Okay.
Yeah,
Thank
okay. Okay, so I'm going to start with quite a broad question, first of all, Commissioner, and that is really about the impact the judgment had in terms of queries, contact from the trans community to your office. Have you seen an increase, a change in the type of inquiries, etc.? So just to give us a bit of a flavour of the impact this had on the trans community since.
Okay, since the For Women Scotland judgment has been issued, we have had a number of queries. They haven't been that large in number, but they have been from individuals who have been contacting our disability advice line, where they themselves feel that they may be impacted by the judgment. And then we also have requests for advice and guidance from employers, service providers and public authorities. I do have those numbers.
We've had about 20 individual inquiries to our discrimination advice line, and then we have about 18 from different public authorities and employers. That is an increase.
Okay.
The numbers on these issues would not have been numerous over the years.
Okay, that's just useful to have that. And I suppose that leads me on to my next question then. You'll be aware that our inquiry into gaps in equality legislation is still ongoing pending this case, and I'm just wondering if you have anything further to add in terms of the benefits from a Single Equality Act in Northern Ireland, given what you've sort of learned through this court case and the impact and the fact that was on the basis of the Equality Act in GB, etc. So just if you have any thoughts on how useful a Single Equality Act in Northern Ireland would be for this type of scenario.
I think the benefit of a Single Equality Act is to bring all of the protections into one place. We were always very clear that the Equality Act 2010 could be improved in relation to best standards right across all other jurisdictions. And I think if you were to talk to the ERC, they would probably say the same. As it stands, the Equality Act has additional provisions that we simply do not have in Northern Ireland. We have very much a piecemeal approach. So yes, a Single Equality Act that addresses all of the shortcomings would be appreciated.
Okay, thank you. So just in terms of your submission there, you've talked about employment code of practice, and you said that would be guidance upon which employers could rely upon. So what standing would that have? Would it just merely be guidance, or do you think that there will be obligations placed on employers going forward?
A code of practice in terms of employment would be something that we would have to present to the Department for Communities, who would ultimately lead before the Assembly. The standing of that code of practice would be that it would be capable of being used as a defence by an employer or service provider in a tribunal. But there is no legal obligation upon those parties to actually use that code of practice, but it is a form of defence should someone take a discrimination case against them. If it is merely guidance that's issued without being a code of practice, it can be used in a tribunal as a form of defence, but there's no obligation on the tribunal to actually do that. It's at their discretion. And that would be the two different sort of legal standings of those codes of practice. But in terms of the code of practice, we have issued a code of practice previously in terms of employment. We have no varies to do so under goods, facilities and services, unlike the EHRC over in England. Mm-hmm. But we would want to involve all of our stakeholders in the consultation process around developing that. Mm-hmm. And we would take it forward in that regard. But the decision to do that hasn't actually been taken as yet.
Just to add, I think our initial thinking was because we don't have the values to do it on GFS, goods, facilities and services. I think our initial thinking was we would be doing guidance rather than a code of practice on employment. Would it seem the most straightforward way of, and then it would be a quicker process as well.
Okay. Just one last question for me then, and it is on that issue of varies and the difference between your equivalent so to speak, body in GB and here. Is it something do you feel, as equality law has evolved in other parts of these islands, that it would be beneficial for your office to have increased powers and functions?
Yeah, but I suppose I have to qualify that by saying about the actual resources at our disposal. There's no point in having additional powers and responsibilities if we haven't got the resources to do it. There would be certain aspects coming forward in the Equality Standards Directive that would address some of those shortcomings. But yes, it's a movable feast, and we can only work with the resources that we have at our disposal.
Okay, so just as a small one then, in terms of the financial position of the Commission at the minute, I know it's not necessarily a question we're expecting, but is there be any commentary really in terms of your allocation from the Executive Office, in terms of your ability to manage your full workload at the minute? Maybe that's...
You want to touch on that, Neil, as Chair of the Audit and Risk?
Oh, yes.
Our budget, certainly in my experience as Chair of the Audit and Risk Committee, it's been at best flat over the last several years that I've had responsibility for that committee. So flat in real terms means continual reduction every year, and that's been reflected in reduced numbers of staff, and indeed the reality is that on occasions over the past several years when I've had responsibility for the laying of the annual report and accounts, our budget has been balanced really by reduced costs and staff. That's what we've relied on to balance our budget, and relying on things like agency staff rather than permanent staff. So fits in very well with Geraldine's point that we do desire greater powers, of course, but we need the resources to deliver on those powers.
Okay, thank you.
I'll just add to that
Yes,
as well,
please.
that in real terms, since 2008-10, whenever austerity first came on board, our budget has effectively been cut by 58%, which is that's it in real terms. But in addition to that, we've actually had additional responsibilities placed upon us as well. So our staffing level is well below what has been discussed and agreed in more recent times. I think we're sitting presently in around 64.
Yeah, our complement's 131, and at the end of this year, it's 60. We've been down 16 staff in this year, and it is because we're trying to control our budget.
My goodness, okay, thank you very much. Deputy Chair, please.
Thank you. Thank you very much for joining us this afternoon, and thank you for the very clear explanation which you've given to us in terms of where you as an organisation are, because I think all too often you're kind of blamed for being a campaigning organisation. You obviously have a very clear responsibility to inform the public about equality issues and equality rights, but I think what you've set out for us this afternoon has been a very clear indication of where you see your responsibilities in terms of getting that legal clarity, which will then filter back down both to businesses, to organisations for goods and services, and to individuals who may feel that they've been affected by these particular decisions. Can I ask you first of all, just in relation to the Dillon judgment, two aspects of that, could you maybe just flesh out for us where you still see gaps in that in terms of giving you clear advice? And the second aspect in respect of that is what those areas that Dillon has provided clarity for you on, what have you done to disseminate that information to the wider public sector?
Okay. Can I ask you at the outset to bear in mind that there are two organisations involved in this, in the dedicated mechanism, and that is the Human Rights Commission and the Equality Commission, and our remit is specifically in relation to the equality of opportunity and the protection against discrimination. The Windsor Framework makes reference to the rights safeguards that are contained within the Good Friday Agreement. And I have to say that at the outset, when we were approached by government, I want you to bear in mind we did not ask for this role. This role was given to us by the UK government, but whenever those discussions were taking place as to whether or not we could do it, we asked very clearly that could they give us information as to how this would all work, because it was something unknown, and hence the explainer document was developed. And it made clear that the bullet point rights within the Good Friday Agreement were covered, and that the non-diminution and the dynamic alignment bit would apply to the Annex 1 directives. Now, Dylan has really narrowed down the issue of civil rights in particular, in that it has made reference to the bullet points, that the opening line within that paragraph, it can't be seen as being wide. It must actually satisfy the demurral test in terms of being concise and enforceable. So the issues around the civil rights bit, that is a piece of work that we have not been looking at as yet. We are looking at the Annex 1 directives. Now, the Dillon judgment has made clear in paragraph 118 that the Annex 1 directives are capable of direct effect, and in addition said that some of the other aspects of the bullet points in certain circumstances could be capable of direct effect as well. So there's also the reference that's made to the resolution of sectarian conflict. So there's issues. The commentary around the Annex 1 directives was obiter dictat. And that means it wasn't required specifically to be considered in terms of dealing with the issue before the Supreme Court at that time. I think you'll see from paragraph 118 the comments that all of the parties that were in the room, the Secretary of State, the family's legal team, and the Equality Commission and the Human Rights Commission all agreed that the Annex 1 directives could be directly enforceable, and the Supreme Court said they agreed to. But then when you move on, there's some other paragraphs that refer back to the bullet points, etc. So we're looking for clarity as to when they actually apply and if we have to apply that additional lens. Because whilst it is obiter dicta, it has the power to influence lower courts and tribunals, although the Supreme Court did say that it was not part of their judgment as such. But while it's there, I think it's important that we all get clarity on how that actually applies. To say that the Annex 1 directives apply, they have capable of being direct effect, that actually brings in the anti-discrimination provisions of those 6 Annex 1 directives that would be engaged with the For Women Scotland. Does that answer your question?
That's helpful. Just in terms of public dissemination or organisation dissemination of the Dillon decision so far, what advice or guidance have you given?
Well, what we have done, we have immediately withdrawn issues from our website, papers from our website that relate to the understanding of the scope of Article 2. Okay. I think it's clear, I need to put on record that we have been very open from the outset that we were defining the scope of Article 2 in good faith, in line with the explainer document issued by government and legal advice. But in the absence of a real robust definition of the issues that arise out of Dillon, we feel that we are not in a position to give very precise, clear guidance to anyone at this point in time until these issues are resolved.
That's very helpful, and appreciate very much that you have done what you've done in terms of revising your advice and guidance at this stage. You made reference then to one other aspect of your work, which is the prevention of discrimination, and you also made reference to your discrimination helpline, where you've had a number of calls, or an increase in the number of calls in the specific area around trans women and men. This is a very small cohort of people in Northern Ireland, a very scared cohort of people in Northern Ireland today, I guess. People who very well feel that they're being punched down on by players over which they have no control or responsibility for. How have you been handling that in terms of not just saying to them that we need clarity with regards to your position with regards to this decision, but what additional support have you given to people coming to you who obviously are and can be in a very distressed state?
Yeah. I think it's important to be clear, first of all, about the advices that we were given prior to the For Women Scotland. During the period from the introduction of the Gender Recognition Act back in 2008, it was our guidance really depended and was subject to case law. And there were two sort of seminal cases that defined that guidance. And one was the House of Lords judgment in A versus the Chief Constable of West Yorkshire Police. And this involved a trans woman who wanted to be appointed as a police officer, and etc. The outcome of that was that the law lord stated that if a trans woman could not be visually distinguished between another woman, that person should be treated as a woman. That was one case. And the other case was Croft versus Royal Mail, which came out a short time after that. And it was focused on a person who had embarked on a process of transition, wanting to use the toilets of the gender that they were going to assume. And the findings of the tribunal and the Court of Appeal was that those rights could not be asserted on the day that you commenced transitioning. What it said was, at some point in the future, you might acquire those rights, but not immediately. So that was the basis of all of our guidance. And indeed, that's why probably I could say that the Good Law Project is seeking a judicial review, because we have never supported or advised that anyone could self-identify and use women's facilities or same-sex facilities, whether they be toilets or change rooms. That was never part of our guidance. So in terms of giving support, we have been very clear in terms of the fact that the respect and dignity for all parties is paramount in all of this. It's a balance of rights. People have rights, and one set of rights does not trump another.
Okay, just
Much appreciated.
Thank
you very much.
I'm going to bring in Philip, please.
Thank you, Chair. Colleagues, thank you very much indeed. Obviously, the Equality Commission occupies a unique position here in public life. You're entrusted with significant powers, significant influence, and ultimately a significant amount of public funding. And there is a growing concern among sections of the community that the Equality Commission has moved away from its core purpose of ensuring equality of opportunity and has moved into the political space. I know, obviously, Chief Commissioner, you will refute that, and we can tease that out. But I just want to turn to your evidence at paragraph 14. So the Commission has adopted, in essence, a position of neutrality on the substantive point, recognising that there are arguments both for and against sex, meaning biological sex, for legal purposes in Northern Ireland. So in the Commission's view, what are the arguments against using biological sex as that definition?
If we knew the answer to that, I'm trying to be as honest and as open here, we would not be embarking upon this particular strategy of trying to get legal clarity. If the Annex 1 directives do apply, then do various instruments of EU law apply? Where is EU law taking us? Because if it differs very greatly from the stance that our current legislation provides for, if it is moving in the direction of self-identification, for example, what we would be doing is documenting that, coming back to the Assembly and to Westminster and saying, this is where our legislation currently sits. This is
your
what
point in your evidence, Chief Commissioner, says that you recognise that there are arguments both for and against. So in your view, what are the arguments against sex, meaning biological sex?
The only arguments that we believe that can be constructed are around the gender recognition certificate and the standing of that and what rights that affords people. It's about the balance of rights that the EU law might be taking us in a direction of. We have always maintained the view that you cannot assert the right to enter into the same-sex facilities in a gender that you acquire to have. We've been very clear on that. But we were at the stage, in line with the initial Scottish judgment, that once you would have a gender recognition certificate, that you would be in that position of being classified and able to use those facilities. Now, you've got to remember as well that from early 2020, as case law was starting to develop, the public debate was becoming really toxic. We were feeling really uneasy in terms of where we were with our guidance. So we actually retained the services of a legal team from London based on the Equality and Human Rights Commission and their codes of practice, and where the public debate was going to develop really robust guidance based on the law at that stage. And we were at the final stages of that when the Supreme Court issued their judgment, which meant we had to park it once we got the inquiry about the applicability of Article 2. We would have had our guidance out by now had it not been for that.
But Dylan was quite clear that Article 2 of the framework cannot be stretched beyond reasonableness. And I think you, as fairness in terms of the Equality Commission, probably recognised that in the fact that you withdrew some of your guidance.
We did. We withdrew our guidance because there were so many uncertainties that needed to be thrashed out. But if I could refer you to the judgment and paragraph 118 in particular, that states very clearly that the directives, the Annex 1 directives, are capable of having direct effect.
In certain circumstances.
In certain circumstances. And it's what are those certain circumstances, because we can't answer those. And I have to say as well that the Commission does not have any judicial decision making in all of this.
I know that.
We have always been very clear that ultimately it's the courts and tribunals who will determine if there's been a breach of Article 2.
Yes.
We give advice and guidance, but we do not make the decision.
In terms of resource that has been used by the Commission to date, so how much money did you spend in intervening or becoming a notice party is probably maybe a better term in the Dylan case?
We weren't a notice party, we were interveners, and the purpose of intervening was to
I know
assist.
the purpose, but how much did you spend?
Have you got the details there?
In total, in all of these matters, while not able to disaggregate everything individually completely, in total, we believe that we know that we have spent 55,000 plus VAT. I should add that includes us dealing with the judicial reviews taken against the Equality Commission in these matters as well.
Just to clarify, in Dillon, in the last stage, Dillon was about 35,000. Around that, the 55 is the case to the date, plus the 2 JRs.
And then, is that one of the biggest spends that the Equality Commission in a case has?
No, I could say that the judicial review that was taken against the Commission on the case of the Children's Law Centre and the budget.
Yes. What about whenever the Supreme Court case that you lost in relation to the Asher's case? Would that not have been a bigger spend?
I think we're on record of 250 or a wee bit more than that over the county court. That was over a number of years from 2014 or.
Can I also say that the money that we are spending in relation to the For Women Scotland and Dillon is not coming from our core budget, but it is funded through Treasury and the funding.
It's still
public money. Absolutely, it is.
If you let the Commissioner finish.
But I do want to make it clear that it is money that has been provided to us by UK government specifically for the purpose of clarifying Article 2. It's not designed for any other purpose but that. The Human Rights Commission and ourselves each receive a sum of money, and that has been agreed for, I think, 2 more years in terms of the work that we do. Okay. But it is ring-fenced and it's specifically for that purpose.
My final
Chair, there are essentially 2 approaches to the finances on this, and there is public involved, we acknowledge that. There are essentially 2 approaches. The approach that we are taking is to invest upfront in seeking the clarification that's necessary to give the answers to employers and organisations and individuals. The alternative approach is to leave it to the gradual clarification over time of cases, JRs, tribunals, court cases that are taken, and in our view that will be substantially more expensive both for the Equality Commission and the public purse at large.
Okay.
My final question is just here, and obviously from my perspective it's still public money, and whether it's ring fenced, it comes from UK government, it doesn't matter, and in my view all public money should be spent appropriately. You may have noticed today that the head of the civil service has issued a notice to all of her staff to state that in light of ongoing legal proceedings and the current circumstances, members of the Northern Ireland Civil Service cannot take part in political campaigning, particularly around Pride events. You, Chief Commissioner, were at pains to make clear at the start that the Commission is not an activist body and your commissioners are not activists. So I assume that you have issued a similar directive to the Equality Commission and to members of your staff that it would be highly inappropriate for them to be involved in an official capacity at any forthcoming Pride event.
Yeah, I can tell you that in probably 22-23, there were about 4 or 5 members of staff who actually participated in the parade. Each year we take a stand from which we provide leaflets and engage with people in terms of what their rights are under various pieces of legislation, and that is part of our education and awareness raising programme. But we have been very clear that we do not engage in those kind of events, and no one has participated in the parade since that time. We do not get involved in political activism, nor should any of our staff be doing that either.
Okay, thank you very much. I'm going to move now to Anya, please.
Thank you, Chair, and thank you all for coming in today. Obviously, with the ongoing legal case, I'm going to try and be as concise as possible with my questions, but I suppose given the lack of legal clarity at the minute and the vacuum...
Sorry, Anya, could you lean into the mic a wee bit? It's just the background noise, thank you. Sorry,
given the lack of legal clarity that we have at the minute, and obviously the vacuum that many organisations, particularly statutory bodies, are working in, and I know the Education Minister had removed some guidance for pupils in schools in September of last year. From your point of view, how should statutory bodies and other organisations proceed within the current space that we're in?
As part of our legal paper that we issued, our strategy as to how we plan to resolve the legal issues, we did include some information, what we called interim information. And at the heart of that information was the aim to provide respect and dignity for everyone, and we set out that quite clearly. We're not in a position to issue guidance, but we do talk to people and answer their queries on an individual basis. We advise people to come and speak to us because every set of circumstances are different, and we will try to assist them in how to best protect the dignity of everyone that's involved. Because, it's based on the guidance that we issued before the judgment that you could not self-identify and just use public space. There was another part to your question there which I have sort of forgotten.
Just in terms of the procedures around statutory bodies and organisations, obviously you've mentioned there around the fact that they can come nearly on a case-by-case basis, but even I suppose broader to that, on a case-by-case basis, and again this is very niche is the wrong word, but it will depend on policy to policy within each organisation. Just from the Education Department's point of view, did the department approach yourselves in
before
terms
they
of,
removed the guidance? I have to say that we had actually approached the Education Authority before it was removed in terms of having some concerns about it. So we had already identified that there were some issues that didn't sit easy with us, but we had not been told that the Minister was going to withdraw the guidance in the way that it did happen, but I have to be honest and say we had flagged up some issues.
And in terms of timescales, I know when you're written briefing, there has been some dates potentially mentioned, September. So I suppose from now to the end of the JR itself, what roughly are we looking at?
Judge Michael Linton was very clear that he wants to make sure that everyone who wants to have a say will have a say, and was very strict in terms of setting the deadline of the 28th of June for any party to notify their desire to be either an intervener or a notice party. To date, we have a number of notice parties, and from the very outset of this, we have had representation for the Secretary of State and the Cabinet Office, Department of Education, Good Law Project, Rainbow, Women's Rights. We now have the Commissioner for Children and Young People, and we have received confirmation that PSNI want to be a notice party as well. So the time frame is we have another review hearing in the courts on, I think, the 7th of September, and Judge Michael Linton has set aside 2 weeks commencing the 30th of November for the leave hearing itself. He seems to be keen to move it on at pace, but depending on the outcome of the discussions and the number of different parties will determine how much of the 2 weeks is required, and if leave is granted, then we would anticipate the actual hearing itself being in the spring of 27.
Okay, and just one final question, Chair,
Oh, yeah.
just in relation to guidance and any correspondence that you have had. Obviously, I mentioned the Department of Education there. Any guidance or any correspondence or engagements, probably a better word, with departments and other statutory agencies. Apart from the Department of Education, has there been any other engagements with?
Absolutely. We have embarked on a really rigorous programme of engagement. On our consultation phase, once we had developed our legal paper in relation to the uncertainties and the issues that needed to be resolved, we embarked on a consultation of 12 weeks, I believe it was, 12 to 18 weeks. We had meetings with all of the departments, trade unions, employers. I can give you the precise figures if I could find it. Number seven. Just to tell you who all was involved in that. 12-week public consultation, during which those who were consulted were asked to respond to 6 consultation questions. We received 39 written responses, of which 21 were from individuals, 18 were from organisations. And in respect of organisations, 8 were from public sector bodies, 7 from civil society organisations, and 3 from other organisations, including 1 from a political party, 1 from a trade union, and 1 from a law firm. We have engaged with people by asking them to come in and meet with them. Louise and I went out and met with other organisations to try to be as open and transparent and actually encourage people to give their views, whether they agreed with us or not, because if this process is going to deliver meaningful results at the end of it, we need everyone's views on the table, because that is the only way in which a true, robust definition and clarity can be secured when everyone has had their opportunity to speak.
In terms of those consultation responses, are they available publicly?
Yes, they're all on our website, as is our original Order 53. The note that we submitted to the court on the beginning of June, and in due course over the next couple of days, our Order 53, our revised Order 53, will also be on our website. We have a dedicated web page because we want to be open and transparent so anyone can look at it. We have actively encouraged people to, particularly the civil service departments, to engage with the process and to either be a notice party or an intervener, because regardless of what people's views are, whether you're pro-trans, pro-women's rights, your view is valid and important, and they all need to be in the mixing pot. And Judge Michael Linton has been clear on that as well. He wants everyone to have a voice. Now, we've had a correspondence from many of the organisations that we engaged with to say they want to be kept informed, and they're not at this stage going to declare whether or not they were going to intervene or ask to be a notice party. We will know by the 28th of June as to whether or not that number has increased, because we were hoping that organisations such as the Human Rights Commission, who would also have a remit in terms of other rights, we were hoping that they would engage, but at the moment we don't know whether they will or not.
Okay, thank you. Timothy, please.
Thanks very much, Chair, and good to have you along. Finally along to committee this afternoon. So we've heard you take a stand at the Pride Parade. Does that cost you any money?
£300-400 or around that.
Who's that payable to?
Pride Festival.
Will you fund the Pride organisation to take a stall? What other parades do you take a stall at and fund organisations?
For example, Mela, Disability Pride in Carrickfergus. Over the years, various different special, to promote rights.
Big events.
Sorry?
Big events.
Big events. It depends on what the issues are, whether it's something that there's potential for people to be there that fall into one of the categories where we have legislative protections for. It could be employment rights. We have taken, we've been involved in events where the employability of disabled people, for example, where we're promoting that. So it's on a wide range of issues, and each one is considered on its own merits. But we do not support, I'd say, for-profit organisations. Being very clear on that.
Yeah. Sorry, can I just
The
add?
12th day, what events do you attend?
So, just for example, it depends on money. You can understand as well. For example, for a number of years we went to the Ballymal show, and we don't have the staff or the resources to do that anymore. So, unfortunately for us, we have to really limit our engagement because we have lost our entire. We used to have an outreach team. We've lost that entire team. So, we don't do that as much as extensive, but we do choose.
What 12th day do you attend?
Well, can I say that we usually attend events on foot of an invitation, and we have never received an invitation to attend any 12th day events, and we would gladly welcome such an invitation because equality is for everybody, and we are at great pains to encourage wider society to recognise, because if I give you an example, demographics are changing in Northern Ireland, populations rise and fall. We believe that the Fair Employment and Treatment Order, for example, is every bit as important today as it was back when it was first introduced in the late 70s and at the time of the Belfast Good Friday Agreement in 1998. Because it isn't just there for one side of the community, regardless of people's views or how it might have been politically weaponised or whatever your terminology might be. It is there for everyone. So as one population rises and the other one falls, they still do require that level of protection as the others did before.
So you recognise Pride as a political event and you don't permit your staff to take part in it. At the start you were very keen to say that you distance yourself from the allegation that's been made about the Equality Commission being activists. Mm-hmm. But surely going to that event is taking part in political activism.
I would disagree with you respectfully in that regard, because part of our remit under all the various statutes is to educate and raise awareness of people's rights, to challenge discrimination, to promote equality of opportunity. Some of these groups are really hard to engage with, and if we
understand why, when you spent 150,000 to take Ashers to court, could you understand why Christians then are saying, maybe don't want to engage with the Equality Commission because they're only interested in one side?
Well, that's really far from the truth. I would love to be able to give you detail of the religious background or political viewpoint of people that we have supported. But I think if you look even at the press coverage that we have received on foot of settlements for individuals, you'll see they're from right across Northern Ireland society, and both in terms of political viewpoint, religious breakdown, etc., etc. We do not favour one more than another. And if you could assist in getting us an invitation to attend a 12th event, I would very much welcome it.
And you're happy to pay £400 for the
absolutely.
pleasure of going, so.
Absolutely, if we are required and we have the resources.
Yeah, sorry,
Yes?
sorry, can I just say to members, we have to, if we're asking a question, we have to allow the one of our witnesses to give a substantive response. And
I'm just very aware there's only 8 minutes.
well, I gave somebody an extra minute there, so you've actually got 9. Go ahead, you've
Thanks
halfway
very much.
through.
If I could turn your attention to the submission that you have given us, provided the committee with, very, very useful. Paragraph 6 on page 2, you cite a number of pieces of legislation. 6, Discrimination Order 1976, Equality Pay Act 1970, and Section 75 of the Northern Ireland Act 1998. So is the Equality Commission's position here today that those pieces of legislation are unclear on what the terms male and female mean?
Sorry, are those
pieces of legislation, so as you sit here today, are you unclear on what male and female means?
I'm very clear about the biological definition of male and female. What we are unclear about are the protections afforded to men and women and people who have a gender recognition certificate or are trans. But if I take, for example, Section 75 of the Northern Ireland Act, which really goes back to the Belfast Good Friday Agreement, and it talks about equality of opportunity and assessing the impact on a whole range, on the 9 categories set out within the legislation. And one states men and women generally. Now, where do people who have transitioned or changed their gender, where are they and their views and the impact of policies on them taken into account. And that is one of the things that we're looking to get clarity on, as to, does men and women generally, that's the words within the legislation, does that word generally have a wider meaning, or does it not?
So if we look, you mentioned the Dillon judgment in paragraph 157. I'm quoting from it: we agree with the Court of Appeal that it is not sufficient that an EU competence may be engaged, and that the Charter has no implication unless it is anchored in a provision of EU law which is being implemented. So where in that is the EU law being implemented? Where's it being anchored?
Chapter 157, I think
yeah.
that's in terms of a discussion in relation to
That's
the
regarding the Windsor
Charter
Framework.
of Fundamental Rights.
So it's talking about the Windsor Framework, Article 2.
In terms of the aspects relating to civil rights and the Charter of Fundamental Rights.
So
Is where it's discussing it, because from 149 onwards it says considering next the language of Article 51(1) of the Charter, which governs its scope, it provides, etc., etc. And that is where they're talking about the EU, the Treaty on Union Citizenship and various other pieces of case law. And it's about the position in relation to the Charter of Fundamental Rights. And those kind of questions, I sincerely apologise, but I would not be able to answer those, because human rights is not my background. You would need to address those to the Human Rights Commission, because we only intervened in the legacy case, the Dillon judgment, to provide clarity to the court in relation to the aspects of the Article 2 of the Windsor Framework. And those other issues emerge when you're dealing with the Belfast Good Friday Agreement and the civil rights interpretations.
Come back to the pieces of legislation that are listed. So those pieces of legislation, do they refer to sex or gender, in your belief?
They refer to sex, but they also make reference to the Gender Recognition Act.
Of its sex. Back in February 2025, in response to a press query, an Equality Commission spokesman said the Sex Discrimination Order 1976 prohibits discrimination against men and women on the grounds of sex. In that context, the Sex Discrimination Order uses the word sex instead of gender and refers to male or female, so surely that's referring to biological sex.
It does, and that is where our position has always been, and our advice and guidance pre the For Women Scotland judgment. And we took into account the judgment from the inner court or session of the Scottish Court, which stated, built on or expanded the judgment from Croft versus Royal Mail, that actually put a point on the timeline where someone might acquire the rights of their acquired gender, and that was when they had a gender recognition certificate. Our legislation in Northern Ireland is quite clear in terms of how you get a gender recognition certificate, and from our understanding, there are only about 60 people in Northern Ireland who actually have a gender recognition certificate. I could be challenged on that figure, but it is a very small figure.
We're
Just have
9.5
small-
minutes, no, because every time you say it's a small question,
It's a
it's never
small one.
never a small question.
I will
One
try-
line,
Right,
one
so-
I
line.
will try and answer it very briefly.
Okay, one line
So-
each.
Take time.
Is the Equality Commission a member of the Diversity Champion Scheme?
No,
Never been.
never been.
Okay, thank you. I'm going on to Claire, please. Online. Thank you, Claire.
Thank you, Chair. I suppose my thoughts on the court judgments were that we never really should have been surprised by those, because ultimately judges interpret what has been put in front of them in form of a law that was decided by parliamentarians or legislators, if you like, and they will look to the context in which that law was made. And then they've come to that. So ultimately, if there are issues in relation to that judgment, the issues with the law in itself and how it's interpreted, rather than whether people like it or they don't, and ultimately if they don't like it, then they go to their legislators and they ask them to change that. And I think that points to the kind of limitations of the Equality Act in England and Wales. It also very significantly points to the limitations to equality law in Northern Ireland as well, because whilst we come over that overarching judgment of the Supreme Court, we don't actually have any legislation which clarifies what is needed. So I'm very sympathetic to the Equality Commission's interpretation of what that is, because ultimately, if we're complaining about that, then we as legislators take on that charge and we create the appropriate law to provide that clarity. And I suppose just asking from a perspective of a commission, and I know you've done an awful lot of work in relation to nearly advising the government, because that as a commission that's your role as well. Are you advising, the Northern Ireland Executive to say, look, this is the gap, this is the problems we're now experiencing because the legislation isn't competent or just doesn't exist? Therefore, you have a responsibility as legislators to improve that so that we do have that clarity. And I think you've sort of made it in comments to other members that as society changes and move forward, even the definitions of men and women, so gender identity versus biological sex has never been defined in law as such, and we have to go by the assumptions of what that means. And a lot of our law is based on an assumption that existed at a point in time when we just weren't having these conversations. So what are we doing to update that so that we can ensure that we have that clarity? Because from what I'm hearing, there's a lot of criticism on people's interpretations, but there's not that much criticism on the legislators who have the ability to provide that clarity. And declare an interest, I'm obviously in the process of trying to write a piece of equality law. We're down to the wire in that, but we'll see how we go in the next while. But even in the absence of GFS, we're, people like yourself, the general public are putting in a really difficult position because we just don't have that law in place. So I suppose I'm just keen to hear your thoughts on what we as legislators need to be doing to really respond to everything we hear in this space.
You're absolutely right that the Commission is tasked by statute under a number of different pieces of legislation to provide advice and guidance to the Executive and to Government under Article 2 of the Windsor Framework, where we identify that there is an issue. We will be raising that with the Executive Northern Ireland Assembly and with the UK Government. And in one of the earlier questions, I can't remember who it was that asked me it, I did say that we were looking to get clarity, and if EU law took us in a direction that was away from where we currently are, we would not be saying this must change. We would be saying this is the situation. This is where we should be going. What do you want to do about it? Because ultimately it's down to our legislative to actually make that law. And it's the same in Westminster as well. We would be making recommendations based on the information that we have gathered and the advices that we have been able to secure as to what needed to happen. And we have done that on all of the statutes that we have responsibilities under in terms of law reform, where protections needed to be improved, where there were gaps in our legislation. Because you've got to remember that the legislation and the protections in Northern Ireland are way, way behind what the rest of our colleagues in the United Kingdom have. And Northern Ireland is being disadvantaged in that regard, in our opinion.
Yeah, and I agree with that. And just even through my own work on my private members bill, I see that in itself is a unique piece of work because it is trying to bring together all of the kind of patchwork of equality law that we have here in Northern Ireland, and it has been a challenge in that respect. But do you feel that the Executive in particular are hearing that? Are they taking that advice on board in respect of what they as legislators should be doing, or do we, is it just another symptom of a government that disagrees on a lot of issues despite being in government together?
I only make a personal observation and not one on behalf of the Commission in that regard, because it's not something that we have discussed or agreed in any particular way. I did say earlier that I think equality has been politicised over the years. It is not for one community over another. It is not a zero-sum game where if one gains something, somebody else has lost. It's for everybody because there are older people right across our society. You're not disabled because of your religion or your political viewpoint in the same way that sex isn't applicable just to one side of the society or the other. We are in the business of promoting equality of opportunity for everyone who lives and works in Northern Ireland.
Yeah, no, look, I agree with that. I suppose I'm frustrated that the role of the Equality Commission isn't fully utilised by those who commission it, if you like.
Yeah.
And I think even from a committee perspective, Chair, there's more that maybe we need to be doing to recognise the value of our commissioners and why they have been appointed in the first instance. And it is as much about advising on equality legislation and policy as it is upholding what it currently exists. You know, we're not in a static state. We should be always seeking to improve, and I think that's where the commissions have a role in advising, and I'm not sure it's being heard. So thank you.
I've been on record anytime I go to one of the committees, and when I'm talking to senior civil servants, reminding them that the Commission is the independent advisor in relation to the issue that's under discussion or consideration. We're not a lobby group, we're not activists, we are not promoting one agenda over another, but we are looking at the legislation, looking for gaps as to where people are not protected, and ensuring that we have the same rights and protections as the rest of our citizens in the United Kingdom.
Thank you. Thank you, Chair.
Thank you. Sinead, please, online. Thank you.
Good afternoon, everyone, and thank you. You've covered an awful lot of ground there, Geraldine, and I suppose your briefing has really provided highlights of the legal uncertainty here in Northern Ireland, and you've outlined the key questions that remain unresolved. And the fact that you're not able to give precise or clear guidance at this stage in the absence of legal clarity is really important. Yet today, the head of the civil service has said that in the current legal and case law context, the Northern Ireland Civil Service is not in a position to participate in Pride events this year. The Northern Ireland Civil Service should be an inclusive employer. Surely, within the context that there is no clarity, why would a decision be made based that the Northern Ireland Civil Service shouldn't take part in Pride? And my concern is, how can the public institutions ensure that our LGBTQ plus community continue to feel respected and included and protected, why these legal questions are still to be resolved? There's such a gap between the two positions that I can't understand why such a decision has been made in the lack of clarity, legal clarity, still to be given, and yet this decision has been made.
In fairness, I haven't seen the decision issued by the head of the civil service and the instructions to staff, so I don't want to comment on that or assume particular issues. But what I would say is that our LGBT community are still protected under the legislation in terms of the Sex Discrimination Order and the Gender Reassignment Act. The protections are there. Respect and dignity at work legislation is still in place under the Fair Employment and Treatment Order. So no one should be asserting one set of rights over another's, because everyone's rights have been hard won and they need to be protected. It's about accommodating and treating people with dignity and respect, because at the end of the day, that's what equality of opportunity is all about. So I don't feel that our LGBT community should be disadvantaged in any way. They still have the same legal protections as they did before the 4 Women Scotland. What it boils down to is a piece of legislation, the Equality Act, in terms of the definition of biological sex. And in some regards, it makes sense in terms of the administration of that piece of legislation. It all boils down to when can a trans person who has a gender recognition certificate, they're not to use single-sex spaces under the terms of the Equality Act. Now, what we're trying to seek is clarity in relation to here. Diversity and inclusion and what might be happening in the civil service, that is for individual employers to be able to do, but we advise them to stay within the requirements of Northern Ireland legislation, because we're very much aware that there are some organisations that would champion the Equality Act and other aspects that fall outside Northern Ireland legislation, without getting into any kind of specifics. As to whether or not people can participate in Pride or any other event, I'm sure that the head of the civil service is allowing people to do it in their own time, not that they'll be pegged to do it. I think individuals' rights would still be paramount in that regard. We don't pay people to participate in Pride. We pay to take a stand to fulfil our education and awareness raising obligations.
Northern Ireland civil servants have quite often attended Pride under the civil service banner, and and it's a celebration and a recognition of their value within the Northern Ireland civil service. I'm confused. You know, has the head of the civil service gone to you for advice and guidance on this issue at any stage? Because she has clearly said in the statement, in the current legal and case law context, the Northern Ireland Civil Service is not in a position to participate this year. So I'm just wondering what that legal and case law context is, because there is no clarity, and you've quite clearly gone to great lengths today to give the formal position, and you're waiting for that clarity and purpose to come forward. So where are we at with this?
To the best of my knowledge, no one has approached the Equality Commission in regard to this decision. I don't believe that that's the case, but if it is the case, if someone has made contact, none of us here are aware of it, and I will come back to you and clarify it if it is anything different. But I genuinely believe there has been no communication.
And I would assume,
okay, thank you.
Just to add, a part of our advice is for individual public authorities to take their own legal advice as well. So I assume NICS may have done that, but they haven't at this stage come to the.
I'm sorry that it's not given you much clarity, but we really do not know in this particular instance, and I wasn't even aware of the decision or the background to it in the press release.
Thank you for all your answers today and for the clarification of the current position. Thanks.
Is that you, Sinead? Yeah. Okay. So Deborah just wanted for a short question at the end.
Very briefly, I just want to ask a few questions. Has the Quality Commission ever engaged with Stonewall?
No, we Stonewall is an organisation where you pay to be members. I have tried to research the advice that's given by Stonewall, but you can't get beyond into the advice until you pay your money. It's one of those.
They're Stonewalling.
Your words, not mine. But no, we have never really engaged with them at all. For those organisations that do engage with them, we would advise that they make sure that they're dealing with the appropriate legislation and remind them of what Northern Ireland legislation is about and not what's happening in others. Because there's other organisations apart from Stonewall, and some of them, one of them, I can't remember which one it was now, but it's actually Canadian based. And I've seen legislation from Canada being quoted in some of their documents, and you go, but that's nothing to do with Northern Ireland. So whoever, whatever organisation is using it, my advice to them would be make sure that it is compliant with Northern Ireland law and you're following what is the policy here.
Has any organisations or I suppose businesses or anything, because you talked about engagement that you've had with them, have any of them come to you with some of the, I suppose, advice that Stonewall has given to them in relation to how that would look like from your perspective?
Not from Stonewall. There was one organisation who approached me, and you'll appreciate for confidentiality reasons, but it wasn't about Stonewall, it was about Diversity Mark. And their concerns focused on around the balance of male and female within senior management, and the concerns were that this organisation was quite heavily balanced in favour of females, and they were fearful that they were being asked to further disadvantage males. Now, it was a very general conversation, it wasn't a specific written request, so there may be something lost in the translation. But at least that organisation was trying to ensure that what they were doing and what they were being advised to do was in compliance with Northern Ireland law.
Okay, thank you.
Okay, thank you. So that's everything for today.
Very
Thank you
much.
very much for your preparation and for coming today. If there's anything that you'd like to share with us, go ahead, please.
Can I just add one thing, because Louise passed me a note, and it goes to Mr. Gaston's question about the Orange Order or the 12th of July events. She was able to confirm to me that a former Chief Commissioner actually did attend 12th of July events
in Belfast.
In Belfast.
At the invite of the Grand Master.
And paid to have a stall.
I don't know the answer to that bit now.
I think he was on, from memory, and I've been with the Commission quite a while, from memory, I think he was on the stand. I think he was invited by the Grand Master.
Do you have the year? Do you know what year that was?
It was
Bob Collins, so
that would have been
maybe
for
08, 09, that sort of
12.
time.
It was at
So
least
my
12
age.
years ago. At least 12 years ago, judging by the term of my office and my predecessor's office.
You're happy to attend future
I am,
events?
but I
and
would seek assurances, because you'll be aware that there's been some really negative media coverage about the Commission and criticisms of the Commission and where we stand in terms of being activists and etc. etc. And one senior politician did say that I and the Commission had lost the confidence of the PUL community in Northern Ireland, which I find really disheartening, and I have to say I felt really sore about it, and I've since spoken to that politician about it, but I think I would look for some degree of assurance that it would be a meaningful engagement with people who would come, and I would, if you're going to get me invited to a 12th of July event, come along with me.
Philip, please. Philip wants to add to that.
Thank you, Chair. And, listen, Geraldine, I've disagreed with many of the activities that the Equality Commission has engaged in. However, I do think it's important to recognise, and you'll know the case, that your office has been very supportive of a PUL individual and ensured that he got the outcome that he deserved. So I just want to put on record, whilst I have disagreed with many of the actions you've taken in my direct interaction with the Commission, you have been more than fair, and you ensured that a working class Protestant got the justice that he deserved.
Just one final point, just to reassure you that our Commission, our board, are truly representative of Northern Ireland society in terms of all of its markers and identifiers, and we're actually appointed by the Secretary of State, and that will be the guidance NIO will provide to him or her to make sure that we are truly reflective, and we do go out of our way to try to counter the narrative that we are only for one side of the community, and it's actually the PUL community that I have concerns about as demographics change. And I'm on the record with your own party as saying, no, we would not be in favour of changes to the Fair Employment and Treatment Order, because if the PUL community continues to either stay stationary and the CRN community increases, they need the protections just as the other side needed back in 1998. So I do, and my whole board and the staff officers go out of our way to make sure that we are truly acting for everyone in Northern Ireland society.
Okay, thank you. I'm just going to advise that that concludes Hansard coverage of this session. So thank you so much.
Thank you.
Okay, thank you.
Thank you.
Oh, one last thing.
That's
You
okay.
didn't stay away. I don't know who said glad to see you here eventually.
No, I think we kept rescheduling. I think that was what it
Yeah,
was.
because we were all sitting ready to come, and then we got a phone call to say we'd been stood down. So it was your committee who stood us down the last time.
Fair point, Geraldine. Thank you so much.
No problem.
So I've just a few items, and then we'll take a comfort break, members. So thanks again, guys. So just a reminder, our meeting on Wednesday, the 25th of February this year, in terms of the committee's inquiry into gaps in equality legislation, the committee agreed to defer consideration of the draft final report until after the oral briefing with the Equality Commission. So I'm just going to seek your views on how best to move forward. In particular, members may wish to consider one of the following options: deferring consideration of the final draft final report until after the leave stage hearing, which given Christmas recess would probably be January 2027, update the draft final report to reflect today's session and the developments outlined above for members to consider at a meeting in early September, or revisit the draft final report following the review hearing scheduled for September and any developments that may occur. Any thoughts?
I propose the January 27th.
Yeah, that's what I thought too. Are we agreed on that?
Yeah.
Okay, so thank you. And were there any actions from that, please?
Just one point that I have was Geraldine was going to check out as to whether or not there had been any approach from Hawks in relation to the notification. So we'll ask them for further clarity and a deeper dive into that to make sure if
Just one point I want to raise, Chair. Obviously, the Chief Commissioner had raised on a number of occasions the role that the Human Rights Commission also played in relation to Dylan. Last week, on the back of the ICRIR's evidence, I had requested that the committee invite the head of the Human Rights Commission back to our two committees, so it's just if we could ensure that that's still on.
I'm content with that. Can we schedule that for the next session after summer recess?
We've written to sorry for yourself, Chair. We've written obviously
perfect.
after last week's meeting, Philip, and I think a response has just come in this afternoon, so that'll be included on Friday's pack.
Thank you,
That's
appreciate it.
Okay, content to have a 5-minute comfort break.
Thank
you.
Committee Room 30, Sound. 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 Committee Room 30.
Okay, members, we're back in open session. We're going to move on to item 7 of our agenda, which is an oral briefing from the departmental officials on the Programme for Government's first annual report. So I'm going to refer you to pages 153 to 156 of the pack for the clerk's brief, pages 157 to 160 of the pack for the written brief, pages 161 to 200 of the pack for a copy of the first PFG annual report. And just to advise that also in the pack for information is the following. So 201 to 298 is the Programme for Government 2024 to 2027. Pages 299 to 302 of the pack for correspondence from TO on previously raised PFG and delivery unit queries. Pages 303 to 308 of the pack for the Hansard report of the 5th of March 2025. Pages 319 to 322 of the pack for TO briefing paper on the 11th of March 2026. Pages 323 to 336 of the pack for the Hansard report of the 11th of March 2026, and finally pages 337 to 368 of the pack for the Transforming Public Services annual report of the Public Sector Transformation Fund 2025-2026. So I'm going to welcome to the meeting Ms Jacqueline Richardson, who's the Interim Director of the Programme for Government in the Executive Office, and Mr Patrick Gallagher, who is the Head of the Delivery Unit. So thank you so much, and thanks for coming today and your preparation for the meeting. So would you like to make some opening remarks? Thank you.
Chair and members of the TEO committee, thanks for the opportunity for us to come along again today. Since our last appearance back on the 11th of March, the Programme for Government annual report and the Public Sector Transformation Fund annual reports for 25-26 were published on the 27th of May. So we welcome this opportunity to come today to give you some update on the progress that's been made within those reports. I'll start by providing you an update on the PFG annual report, and then I'll hand over to Patrick, who'll provide an update on the Public Sector Transformation Fund annual report. And we'll keep our remarks brief so that we've got some time for questions. So the TEO PFG team works closely with the departments across the Northern Ireland Civil Service to track and record delivery against the PFG commitments. As set out at the launch of the Programme for Government on the 3rd of March, the Executive are committed to publishing the annual reports to ensure transparency on progress, and as we said, the first report was published last month. The PFG annual report sets out the progress made against the 9 priorities, and it also reflects the wider work underway in support of our longer term missions of people, planet, prosperity, and the cross-cutting commitment to peace, alongside the Building New Foundation commitments. And just to give you a brief sense of the work underway, I'll give you an update on some of the significant achievements that's included within the PFG annual report. So £20 million has been invested in the Skills Fund delivery from July 2024 across 27 key schemes. This has supported 17,000 individuals to upskill and reskill, and 1,100 employers have been able to avail of the tailored training interventions. To tackle the cost of childcare, over 27,000 children and over 20,000 families have benefited from the extension of the 15% childcare subsidy scheme. Families are estimated to have saved £26 million through the scheme, and when that's combined with the the tax-free childcare, it amounts to a saving of approximately £57 million. To help cut the health waiting times, £135 million has been invested and has supported over 237,000 additional outpatient, diagnostic and inpatient procedures which have been delivered. Funding of over £5 million for EVOG has been provided to support the local and regional change funds, including momentum funding, to provide on-the-ground support for the vital work in communities and the sector. To better support children and young people with special educational needs, 157 additional classes have been created for over 1,374 pupils across 123 schools. 1,765 new build social homes have been started during 25-26, along with the delivery of 940 co-ownership intermediate homes. Funding of £20.5 million has been secured from the Public Sector Transformation Fund to help reduce delay and free up capacity in the courts. 20 of the 37 actions in the Loughney Action Plan have been delivered, with the remainder currently being progressed. And finally, to ensure reform and transformation of public services, as well as the Transformation Fund, work is ongoing to improve the Northern Ireland Civil Service digital capabilities, including the establishment of the Office of AI and Digital and developing a cross-government AI strategy and digital capability framework. Work continues as we move into the final year of the Programme for Government. There's no doubt that there will be challenges, particularly with regards to the difficult financial position. It's for this reason that the PFG priority to reform and transform public services is so important in bringing about innovative solutions supported by the Public Sector Transformation Fund. And that's mine finished. On that note, I'll transfer to Patrick.
Thanks, Jackie. Thanks, Chair. So I'll just briefly update on the Public Sector Transformation Fund and the role of the delivery unit. So as the committee will know, the fund provides $235 million up until March 2029 with the aim of testing new ways of working, improving outcomes for citizens and helping place services on a more sustainable footing. So in March 2025, as we discussed last time we were here, there's $129 million allocated to 6 projects across health, and there's over $13 million has been spent to date. So the first year funding was always expected to be a foundational year for projects focused on design, mobilisation and getting going. However, the projects are already delivering tangible early benefits. For example, there's hundreds and thousands of more people can now access a wider range of support and GP practices through the MDT programme. The first natural flood management project has already commenced.
In addition to the work Jacqueline referenced around saying there's more early support being provided to families of children with additional needs in the 2 to 3 year age group, and there's work to speed up justice is already freeing up court and police time, with an estimated 4,000 policing hours already saved through the Speeding Up Justice programme. Importantly, plans for all these projects show significant increases in activity and spend from this year as projects move from planning into design and into delivery. So looking ahead, the Executive has recently agreed a further $102.6 million for 6 additional transformation projects. These build on the early learning from Tranche 1 and will go further in promoting cross-departmental and cross-sectoral working, unlocking efficiencies and delivering lasting improvements in frontline services. So they will improve healthcare access through digital prescriptions and expanded pharmacy services, provide earlier support for families and for those struggling to find work, test innovative solutions to the challenge of bovine tuberculosis, and modernise how government uses data and technology to deliver services. Together, all of the funded projects reflect a shift towards prevention, early intervention and more integrated citizen-focused services. And to maximise impact of this, obviously strong governance and delivery discipline are key. So the Public Sector Transformation Board provides that independent oversight and challenge, ensuring that the funding is directed towards those projects with the greatest potential to improve outcomes. And then the delivery unit supports this by working directly with departments and delivery partners to monitor progress, challenge performance and help resolve any barriers to delivery. So we also identify shared learning across projects and promote a consistent focus on outcomes, evidence and impact. This whole system approach the committee will appreciate is key, as transformation at this scale can't be delivered by individual projects in isolation and requires coordinated effort across departments, partners and sectors. And our priority will be to ensure this investment translates into measurable improvements for citizens and that successful approaches are embedded into mainstream delivery over time.
Okay, thank you so much. I'm going to start off by looking at the Manage Our Water, which is in the Doing What Matters Most annual report, but also then in the transformation document it talks about transforming urban drainage. So I represent South Belfast, so we have had instances of flooding, but we also have large numbers of houses being built, particularly in the Castlereagh South area. I'm actually meeting with NI Water tomorrow to discuss that. So it says in the PFG document about the 15 million for public sector transformation funding secured for a 4-year urban drainage transformation pilot. It would strike me that that won't touch the sides in terms of what the scale of the problem here in Northern Ireland is. So first of all, how is the pilot area being identified? You may not have all the details, in some ways I'm speaking out loud in this, but you know, what will happen if it seems to be a really successful pilot? Like how then are you going to fund the rollout of that? So if you can give me some details of that, please. Yep.
So I'll take that because that fits under the transformation projects, if I can find the right page I've got. So in South Belfast, the Drumglass Park, obviously, I know there's a consultation recently, that's one of the examples of the pond for sustainable drainage. There's also up around Forestside, there's the wonderful leaky dams where they put the tree trunks across the river to slow the flow of water but not stop it, and ultimately try and make the water slower to get down and then prevent the flooding. So what this is trying to do, and what a lot of the transformation projects are doing, is testing those things to see what works. and that is one of the main challenges, is that sustainability piece, because when we know what works, well then you need to do them long term, but equally that should allow us then to stop doing things. So the urban drainage one, for example, instead of pouring a lot of concrete into the ground and creating a lot of grey infrastructure that will just fill with water and eventually in whatever many years time will overflow itself, the plan is to try and test these solutions. And I don't have the full details of that. That's something we're looking at around sustainability with the projects. We had a workshop with all the projects last week and we emphasised, come to 2029, this funding is over. We need to prove that there's been a benefit to citizens, but also that we know what we're doing with this learning and with the impact this has made going forward.
Okay, apologies. I did know about the Drumglass Park, but I thought Belfast City Council were funding it. Is it joint?
It's a bit of both. I hope I haven't misspoken. But I know that example of the pond is part of it. Yeah.
Yeah, no, because we've already had constituents thinking that they're going to attract birds. Or, there's always a counter to all this. But just the wider issue, but in terms of new house builds and the managing, it says here about the new living with water, the dairy, London Dairy Plan, etc. So is there work being prioritised to unlock a lot of the housing developments that need the wastewater infrastructure? Like, is this a priority within that Manage Our Water commitment?
Well, I'll say maybe Jack can come in on the wider PFG. So the urban drainage one is not as, it's around the preventing the flooding. There is a project, I think when the Finance Minister announced the 6 new projects, there are a further 5 projects that are fundable. They're the board has passed them, but the money isn't available yet. So I know that's part of the draft multi-year budget, and one of those is more around the wastewater element. So there it is. They're two related things, but then slightly separate, and that's trying to stop flooding of houses that are already there, whereas wastewater, we know, is a major issue as well. But Jacqueline, maybe say something more around the wider priority.
Obviously, that was the publishing, so the main work will be sort of starting around it now, so I wouldn't know the detail. But I do know that, obviously, over the past 2 years, there's been over 3,000 new build social homes started, and those discussions would have been having, whenever they were going around. But I can find out more information if you like and write to you with the response.
Well, I suppose it's a broader question around, and let's just pick up on Patrick's last point there, around the fact that we don't have the budget agreed and the concern that they'll actually be more constricted. And so I suppose there's a broader question then for you, Jacqueline, then in terms of what will be the impact if there's still a stagnation around the budget, that they don't get more money from the Treasury. How will the programme for government delivery projects be prioritised, impacted, etc.? If you give some commentary on that. Thanks.
Yeah, well, obviously it's an executive document, so it'll be up to the executive to decide where the priority goes. The budget is causing a lot of difficulties, and it is, as we all know, it's challenging for everyone at the minute. So I think it's just, continue to do what we can with what we have, but obviously those discussions will have to come, and those, priority discussions may have to be had.
Okay, but they'll just be like policy decisions by the Minister as opposed to an obligation to go back out to reconsult or re-engage and get views on it? Is there an obligation to maybe re-engage with people around, because you consulted in the first instance on the draft programme for government?
I think at the minute it's just more around let's see what's happening, but obviously that's time's ticking on. But yes, at the minute it's just trying to do what we can within the financial challenges that we have. But yes.
Okay. Two quick ones for me. So, as you will probably be aware, that it was my party colleagues at the executive had pushed for that pillar for the peace pillar in the programme for government. I'm going to look at the projects that are listed there, all great projects, but there doesn't seem to be any new work over and above. That if this programme for government wasn't in place, these would be happening anyway. Is that a fair assessment, or is there more work being done in this cross-cutting commitment as regard peace?
Yeah, I think when it comes to peace, this is only a small piece of, pardon the pun, but it's only, that there's loads going on around peace, and peace, reconciliation and good relations are embedded in the fundamental principles within all strategy and governance frameworks. So throughout the PFG, as you say, you can see that our long-term missions are all underpinned by peace, and the cross-government delivery to support the communities and the good relations. So I suppose what we'd say is there's a lot going on in departments around peace, and we're probably only touching on the very tip of it.
Okay, so just last one for me then. So do we know when we're going to get the draft AI strategy? There was sort of rumour it was coming out sometime around now. Do we know when it's?
I know they're looking at launch details, like it should be imminent, as far as the last I've heard.
Imminent?
Well, that's as far as I've heard, yeah, so it's very soon.
No problem. Thanks so much. Deputy Chair, please.
Thank you. Thank you for joining us this afternoon. What's your overall assessment of the first annual report on the programme for government? Success, failure, or a curate's egg?
I think it's a mix. I think there obviously is a lot that's being delivered, and it shows the key priorities and it shows what is being delivered, and hopefully there is impact being made on the people of Northern Ireland already. We continue to work with the departments to monitor the progress and keep the executive informed on plans and actions as they happen. But I suppose what we'd say is there is still a lot of work to be achieved, and as we've already discussed, the financial constraint at the minute is one of the biggest challenges for us.
Yeah, when I look at the glossy brochure that you've produced, and I looked, and I'm going to concentrate, and I'm sure we could do this in nearly all of the sections, but you have a section on cutting health waiting times, but you don't make any reference to the areas where you've failed. Northern Ireland has the longest cancer waiting times in the United Kingdom, with patients not receiving treatment within official targets. No reference to that at all. You've told us about your successes. You've told us about how you've nearly 100% reduction in weights for colonoscopies, for tonsillectomies, for primary hip care, for knee replacements. And, you know, with due reference to people who've been waiting for all of those things, those are the easy hits. What you're not tackling, or at least certainly what you're not telling us about that you're tackling, are the difficult areas. So, you know, I read the report and I can be impressed by the figures that you've put in it, particularly around health, but you've avoided the difficult areas. Why is that?
I suppose it's not that we've maybe avoided them. I suppose it's, you know, what's in the programme for government, but there would be things like the mega clinics and the elective care centres that you would be hoping would be impacting positively on those people's lives as well. So we've maybe not, you know, called out the cancer waiting times, but you'd like to think that there's things in this report that shows those people have positively been impacted as well by being seen, you know, quicker, waiting times being down, getting their diagnosis quicker so that they can start their treatments.
If I may come in, just because the delivery unit obviously had a role with waiting times, the PFG itself, you know, the first line is it that we have, it calls it out that we have the longest hospital waiting times in the UK. So that was almost your baseline you're starting from is that, which I don't think anyone was shying away from the fact. I think also when we were working with Health and looking at their documents of their reset plan, a lot of the health proposals, they're quite stark. Health will hold their hands up and say exactly where they're working from. The PFG is trying to show what, you know, since that has been almost like taken as the baseline, what has happened since then, and is showing the development and the improvements that have happened. It doesn't mean that everything's great, and obviously in a short enough document, you know, Health could write the same size twice again if they were just talking about health. But I think having the baseline called out at the very start in PFG that we have the longest hospital waiting times here, you know, is what we're working from and what we're all trying to improve, and then this is showing the work that's been done. To talk about your last question, just on the transformation side, I think the success point is around this is year one. Year one was always going to be that starting year around the transformation. The success measurement will be year 2 and year 3, because, you know, we've had the first year to get going, we've had the first year for design and mobilisation, and that's where we really need to see delivery. Is this time next year is when we'll really be able to hold departments to the projects and the plans.
Again, just concentrating on the health area, one of the key things that has been sold in Northern Ireland, and for many people, and certainly from a public perspective, is working well, is the Encompass system, which is the new electronic recording system. Yet, at a recent all-party group meeting, I sat in this room and listened to a consultant from the Ulster Hospital just up the road, who told us that EPIC, which is the internal side of Encompass, has resulted in him and many of his colleagues not being able to see 15 patients in a session, but now only being able to see 10, because the administrative burden has been transferred to the consultant away from administrative staff. So we've spent millions of pounds on developing a system which is not actually a bespoke system in terms of healthcare. It's an off-the-shelf IT system that has been purchased. So there are serious concerns around the way in which we embark on what are perceived to be innovative ways of reducing, in this case, healthcare waiting times and improving communications between all of the healthcare professionals. And yet, in the space of half an hour, when members drill down into questions, there are serious concerns raised. How much of this is being reported back to the centre?
Well, I know from PFG perspective, it's not something that we've, you know, heard about, but
you've invested in it.
Well, yes, as I say, it could be something. If it came recent, it could be that, you know, it's in our next updates that we've not received, because this is obviously as at March 2026. But certainly something that we can keep our eye on. I don't know if there's been anything through transformation.
No, but that's something, you know, around that I haven't been made aware of the Encompass EPIC issue, but we can certainly talk to Health around that.
Yeah.
Thank you, Chair.
Thank you. Deborah, please. Thank you for coming to the committee today. And There is positive things that are happening, and I think we have to put that on record too. You know, in terms of the executive getting back up and going again and getting those wheels turning. There are things within this document that are tangible things that are happening within our community. So there are things that we do want to see happen at a faster pace. And I just want to turn attention to the transformation of public service document and page 31, and it specifically says about where progress is slower than planned or benefits not materialising. Where have you seen so far that those benefits aren't materialising, or where do you foresee that those benefits are not materialising at this moment in time? And then as you go through that paragraph, it says that the delivery unit will escalate those issues promptly, agree actions and get delivery back on track. So if we could take it, those are, I suppose, in two parts. What is not materialising at the minute, or what do you foresee not materialising, and what is happening at this moment in time from the delivery unit perspective to get it back on track?
Yeah. So the committee may have seen then the UTV coverage not that long ago around concerns raised by the Public Sector Transformation Board around some of the projects, and one of them in particular was around the Special Educational Needs project. Now we know that there's a massive issue. Special Educational Needs is a huge issue. A small transformation, relatively small transformation pod is not going to fix that. But what I would say is that was the board doing its job. That's exactly what the board, and that's also what the project should be doing when there are concerns, when they feel that things aren't going as they initially planned, because the point of transformation is we're doing something new and something different. So the board has accepted, and the executive has accepted, that if everything works in all the projects we're doing, then maybe we haven't been ambitious enough. So the board's role, which is obviously chaired by Jane Brady, the head of the civil service, is to scrutinise those projects. And they brought in the SEND project, they brought in all the partners. They had a good open discussion around what the next step were, and then have agreed a tweaked version of the plan. So that's not saying that there's lack of benefits there, but I think it's a good example of the board identifying issues at an early stage and making amends. That point is put in as a marker to say that if and go back to my earlier comments around the first year was getting started, getting going, but as it goes on, if we see that a project isn't working, the board has a very clear escalation route that they could recommend to the executive ultimately that the funding is stopped and the funding is moved somewhere else. So there is that plan. This is the executive obviously made these decisions in the end, but the board has the ability to recommend that no, this money would be better invested elsewhere in the system. So the role of the delivery unit will be to keep on track of that and keep on top of that, so that we don't land into March 2029 and we suddenly realise that 2 of the 12 projects have failed. If we only realise that then that'll mean the delivery unit hasn't done its job, because we haven't been identifying the challenges early enough. So we have set up monthly meetings. My team is going in and meeting each of the projects monthly. They come into the board, reports quarterly, so we can air anything at an early stage, work out what the problem is, help them solve it if we can, but also retain that potential for the board to recommend that the executive withdraws the funding and moves it elsewhere.
So is that the only issue that you see where the benefits aren't materialising?
No, so that's an example of just one, because it was in the media. The UTV had reported on that recently. At the minute, and I'm not saying that that's the benefits not materialising, that was one reported around a discussion over concerns, but those concerns, there should be concerns. Basically, the board should be having that discussion. They should be bringing it up, and they should be sorting things out at an early stage. You'd rather that happen now than happens in 2 or 3 years' time. But the benefits-wise, I listed a few of them at the start. I think there are some clear benefits already around the multidisciplinary teams programme, around the urban drainage programme. Things are starting, but it'll be in the next year and the next 2 years when we really start to be able to say whether that's working.
So if you don't mind, I really want to focus on the things that aren't materialising, so that the board are looking at. So have you figures of what they are actually looking at this moment in time that is not materialising?
So at the minute, there's the 6 projects in Tranche 1, and then there's 6 new ones. So the new ones are only getting started. The 6 in Tranche 1, there's no material concerns at the minute. Now there's challenges across lots of the projects and the context that we're in, and a number of the projects are part of a wider programme and a wider system that stands goes along with that and doesn't just sit on its own. But at the minute, the the SEN one that I reference is because that was in the media. There was minutes of the board paper that the board had concerns, but I would say that that's a very natural part of a board's role and what a board is there to do, and that's been worked through, and now there's a clear plan going forward. But concerns at this stage, I don't think the board has any immediate concerns around the projects. We have given them a RAG rating in this, and I think 2 are green and 4 are amber, with 2 of those improving. So there's nothing in red at the minute, and there's nothing flashing red. But that's part of our role, is to keep checking. It's page 10, the RAG rating.
Okay, I suppose I know it's probably not related to the Pacific transformation of services, but it is a concern. Is net zero targets and how they impact upon projects and delivery of projects. On page 27 of the annual report, we have a list of infrastructure projects, one being the A5, we've union connectivity, we've rail. Those aren't going to be delivered upon, are they? Because of we're currently waiting on court judgment. So how does net zero targets impact upon the delivery of what needs to be achieved? Because infrastructure is a tangible thing that people see.
Yeah. Well, firstly, the ones that you've just mentioned there on page 27, they're under the Build New Foundation, so they're the longer term ones, which are there for for longer term focus, but obviously not to be delivered by the end of this mandate. So just to give a bit of clarity around that. And then around the net zero, I suppose, the executive throughout the PFG have said that they are committed to reaching net zero in a fair, just and affordable way. So without, obviously I'm not over all the projects, but net zero is something, and climate is, very actively being talked about. So I'd imagine.
Is it being actively talked about from a delivery unit point of view?
Well, I'm sorry, I'm talking from PFG, just, that whenever, anything you would see, even in the public domain, it's being, but I don't know.
At the minute, that hasn't come up in any of the 12 projects that we have, because they're not the same sort of capital infrastructure projects that we have, so it hasn't come up on the 12 transformation projects at the minute for us.
I suppose, are you worried about further legal challenges should net zero targets not be reached? Because in the programme for government document itself, on page 16, it talks about supporting the delivery of 80% renewable electricity by 2030 target, and there's targets that we have to meet as a result of that climate change legislation. In the report, correct me if I'm wrong, I don't see any targets or delivery against some of the targets to do with climate change. Where are we? Are we on track with those climate change targets? Because 2030 is not too far away.
I suppose the work is ongoing. So, the renewable electricity price guarantee, it was published back in September 25. The climate action plan was completed, the consultation in October 25. So there is work going on in the background, and there are the carbon reduction efforts around are accelerating, the transition to net zero. So there's mentions like this. Some of the stuff there's maybe not an infographic for, but in our progress updates you will find some of the information. But as I say, there will be more reports coming, and again, we can take this away and look to focus a bit more on that for the next one if possible, and provide more information on that.
It's just we already have legal challenges and court action in place to do with climate change legislation. In my view, climate change legislation is costing our executive, because with every moment of delay in infrastructure projects, the cost increases. And some of the things that I see contained within the documents are not, their cost is going to increase. That's going to have a knock-on impact upon the budget. And you have stated today that the budget is a main block in terms of getting some of these things delivered. I think it would be useful to measure against where we're at in terms of climate change targets and the legislation to meet, because it is wonderful to have documents, but if we're not meeting the targets that is contained within the legislation either, that should be also of concern. Lastly, if you don't mind,
We're
Chair.
over 10 minutes now, but I'll give you a bit of latitude
Okay.
because you didn't ask much earlier.
That's good. Maybe remind that for again. Just in the transformation of public services document as well. I just wanted to check in relation to 47 proposals were received in June 24. Can you just remind me how many were awarded again? Six. So in August 2025 we had 25 proposals. Why? I know we had 6, but why have we so much less here?
So there was a restriction put on.
The
It's a slightly different
restrictions?
process the first time round. Departments could, I think, introduce, it was before I was here, but I think it was 4 or 5 projects, and they could do two below a threshold and 3 above, or something around that. But then we reduced it down to 3 projects maximum per department for the next, just so they could focus on the real priorities, and also to speed up the processing, because the board has to go through all those. So it went from 47 to 25.
Okay. And there's 235 million over the 5 years. By March 2026, I think by my reading there was 13 million spent.
Yeah.
Was that always to be the target, or is
So-
that slower than expected?
It's-
And do you expect the 235 million? Do you expect that there's going to be a need for more?
Well, first of all, on that point, there's more projects sitting ready to go if there is more funding available for these projects. No, that's the 235 has been fully allocated, so that's the money that the executive secured from the UK government. But obviously, the executive can put more money to transformation if it wishes to do so. The spend as of March 26 was 13 million. Well, that only was on the first 6 projects, so the other 6 hadn't started by then. I think that was estimated when the profile spend, whenever they were announced back in March 25, was around 20 million. So it was slightly under, but it wasn't, as you know, it's been reported in some places, it wasn't 13 million out of the 235, because that has been profiled, and we've got the profile, I think, towards the back of how much is going to be spent. So you can see that increases. It's page 26. That dramatically increases in future years, as you would expect. And as I said, the early years around getting started, but then it really needs to get into delivery.
Okay,
Thank you so much. I have 2 more to come in. Anya, please.
Thank you, Chair. And thank you both for coming in to brief us today. I know we had to put it off previously, but it's great to get you in. Patrick, just a question in relation to some of the transformation document, specifically on the enhanced support model through education and SEN. Is the department aware that there has been significant concerns voiced by unions in relation to the enhanced support model itself? And if you'll indulge me, Chair, I just want to read some of the consultation response that has been submitted. Obviously, it closed now on the 28th of May. So there is a quote here from a classroom assistant stating that there's not enough information about what the enhanced support model will mean for children, principals and SENCOs having to take on extra responsibilities and the classroom assistant role. I agree that the education system needs to work better for children with special educational needs, but I do not believe that these changes will fix that, because it's likely to mean schools having to do more with less. They do go on to give some recommendations as to how the Education Authority and the department should pause the process and work together with trade unions, classroom assistants, parents and children's rights groups. So I suppose in the whole there, Patrick, just when it comes down to special educational needs, I don't think anybody will disagree that it needs reform. How that reform is going to be implemented is the question here. And based on that feedback that I have received as a constituency MLA, I don't understand how the enhanced support model itself can be a cornerstone if those in the workforce who are tasked with delivering it don't agree with some of the recommendations within it.
So the enhanced support model obviously was out for consultation in March, but for consultation means, you know, the details
It's
of that
not
will be
fit,
for
yeah.
the Department of Education. But what this project is saying, what the proposal was that an enhanced support model. So we need to everyone recognises we need to enhance the support. What that model specifically looks like will obviously depend on the consultation. So that's one of their key achievements, and that's sort of part of what I'm saying around the spend, is that a lot of the work is developing those documents and getting the plans ready and getting the ideas ready and get the project teams ready. So developing that and publishing that for consultation in March 26 was a key achievement for last year. But obviously the department and the EA will be working through the consultation responses and be working out what that exactly looks like. So that's not something that we've been directly involved in with unions or with constituents, but I know that education will be looking at all that and trying to come up with something that works for everybody, because we all know it's not going to be sustainable to keep things as they are.
No, and I would accept that. Obviously, from your point of view, you are detached at a certain level compared to the department, and you don't have any indication yet, Patrick, as to when the department will have. I suppose that they would be collating the consultation responses now, but you've no indication to date.
No, we can pick that up with them, as I say, with monthly meetings with the department, and you know, this is where the delivery unit is maybe a bit tricky, in that the policy sits with departments and will sit with departments, whereas our job is to drive the delivery and make sure, you know, what they said they were going to do, they've done. But certainly something like that, if there's concerns raised, we can pick up and get some more information on where they are.
Brilliant, Patrick, thank you. Just in relation to additional focuses or issues that have become more apparent, I suppose, as this mandate has moved on and since the PFG was drafted. Two of such are, in my eyes, the lack of an anti-poverty strategy and post-19 special education needs support. Just in terms of the delivery unit, Patrick, have you considered putting an additional focus on some of those issues between now and the end of the mandate at all?
Initially, as it was last meeting, our focus was on waiting lists, and then it's moved to reform and transformation. But post-19 saying, I know that was debated at the times in the Assembly, and there was we have had some discussion with officials in DFE and officials in Department of Health on you know, what's the best way through that, because it's one of those issues that cuts across so many different areas and different people. We are a very small team. There's only 5 of us, so it's trying to make sure we're adding that value. And like I've said, the transformation is almost like our anchor activity. That's our bread and butter, is trying to drive these transformation projects. There is some capacity, but whether that's something the delivery unit will take on, the First Minister and Deputy First Minister agreed that we could scope it with officials and talk to officials. So that's what we're doing at the minute. And I don't have much more to add to that, but if there is, obviously we'll bring that back to the committee at the time.
I suppose that's an update and a positive update at that in itself, that there is scoping going on at the minute.
So there's discussion. That doesn't mean it'll come to the delivery unit, but it's, you know, we're happy to talk to anybody to see, is there something that TEO and a delivery unit in TEO can add value, or is there something that, you know, departments is doing their own? Because the one thing we don't want to do is come and get in the way when departments are doing work or working their way through a really complex, tricky issue. Sometimes a bit of support can you know, do more harm than good, whereas we can focus our attention on things where we know we can add value.
That's okay. One final question, Chair, and just to stay on the theme of health, I suppose, and the investment of £135 million that has been made in relation to waiting lists and driving waiting lists down. In terms of that allocation of money and that investment itself, is there a focus on permanent capacity increases rather than one-off initiatives to get through, I suppose, a backlog here within the next 2 to 3, 4 years, rather than building capacity into the system based on that investment?
I don't have all the details in front of it. I'll take that because of our work with health. But I think it is a mixture of both, of trying to you know deal with the worst ones at the minute and try and do something to get things through. But also, I think if we talk to health, you know, they would raise the multi-year budget again and say that would allow them to plan further and build that in earlier in the year. And obviously the executive has ring-fenced money for health for waiting lists to allow at least more forward planning this year in advance of a budget being agreed. So sorry, I apologize, don't have the full data, but I do expect, from what I remember, it's a mixture of both.
Thank you, Chair.
Okay, thank you. Timothy, please.
Thanks very much. Thanks for coming along. And I admire the salesman type approach that you have adopted to the glossy documents in front of us. trying to sell what the executive has achieved 1 year on. I'm sure that's not easy, but I do admire your commitment to doing that. I want to start off by looking at cutting health waiting times from doing what matters most. So we have here 135 million invested, over 237 additional outpatient diagnostic and inpatient procedures delivered. I want to give you an example of a constituent that we have contacted the Department of the Belfast Trust on behalf of. Elderly lady with Parkinson's disease. She was upgraded to urgent back in February after sending correspondence. On that basis, we thought happy days were making progress here. So this is a lady, to put it in perspective, she has lost sight in one eye and is facing the prospect of further deterioration in the remaining eye due to a cataract. What the Belfast Trust have told her is, so she's been upgraded to urgent, but she's going to have to wait a further 12 months before she could be seen. So that lady has Parkinson's disease. She's in a home and is all but blind because of the Trust not carrying out the procedure that she needs. So while I respect the brochure and progress has been made in certain areas, if I go to that lady and tell her what's in here, that's not her reflection of her lived experience of the Trust. So out of all this money that's invested, out of these 237, we have an elderly lady here who's basically blind. The Trust could do something about it and nothing's happening. What do I tell that constituent?
I know that that's a very difficult position for your constituent to be in, and for anybody to be in. I think everybody would have, everybody has sympathy, and everyone knows and acknowledges that the health waiting lists are not where they should be. As I said earlier to the Deputy Chair, that was called out in the programme for government at the very start, that it's the worst waiting times in the UK, and that's the baseline that we're trying to work towards. The detail in the document is what has been done to improve, and there are many people who will have had long awaited healthcare and will have moved on, but there are likewise many people who are still waiting, and that is the challenge that we are trying to support from TEO, but obviously the health will be leading on and focusing on, is trying to get to all those people who need that support, including your constituent.
Yep. Moving on, the next area I want to cover is under the transforming public services. Special education needs transformation. We have a number of successes listed here, money being invested. But one of the things that we've heard time and time again, and this was really came about, I want to pay tribute to Alma White of Caleb's Cause, where we have young kids reach that age, just turned 19, and yet there's nothing for them. Why I take great exception to that is, over in England, there is a scheme to keep people with SEN needs in school environment until 2025. This executive receives money to do that, but has chose to spend it in other areas. So there's 390 million has been allocated to this executive over the next 3 years because of a significant investment in SEND and English councils. Is there anything in here, or will there be anything in the other 6 projects that you talk about when it goes on about 2027 and beyond, to ensure that people like Caleb will then be offered further education or further provision until the age of 25? Or 25. Looking at it here now, what I read you this. So Caleb's Cause NI, this is a Facebook post that went up 11 minutes ago, where Caleb is attending his school leavers ceremony tomorrow. And there's a paragraph in it that says, the systems are broken, the powers that be are stalling, and once again our kids are not being put first. I'm tired of fighting, tired of the uncertainty. So this executive will be judged not by what's trying to sell in here, but indeed by people's lived experience. The lived experience of the lady that suffers from Parkinson's, is basically blind because of a cataract. All those parents that their same child is now leaving school and that there's nothing for them to go to. If there's adult centres, it's limited provision. There's money has been given to this executive over 3 years. Where's that money going? Where has the money went that indeed was sent over? Is there a commitment? If I raise this with yourselves and the delivery team, will you look at my constituent's case and the cataract surgery? Is that something you can do? Is that something you can commit to?
And not in individual cases, but as I say, they're responsible of the trust and the Department of Health, but on the system level is where we're trying to be involved and to add value and not obviously get in the way of the work Health is doing. But
so the next one I want to take you back to is PFG, Safer Communities. My understanding is there's currently 6,341 police officers. Patton recommends 7,500. There's nothing in here of policing numbers. And bearing in mind with the unrest we have seen in our communities over the last number of weeks, there's nothing in here about the porous border, nothing in here about immigration. Is that something that will feature in the next programme for government? The next year or two?
Well, obviously it's something we'll take away and we'll see what information that we can provide and what information is available to us. Obviously there is the figure about the 7 million allocated to meet the full cost of the workforce recovery plan and the recruitment that's underway. So we've mentioned that on page 19, but certainly happy to take the feedback away and see what we can provide.
So how many officers will that deliver?
I can find that out and provide it.
Moving on then to page 25, looking at net zero. Deborah covered some of that earlier on. So it talks about the commitment ensuring our long-term strategy for 2024 to 2035 delivers smart investments. How much has been allocated to net zero and the targets between now and 2035?
Sorry, can you repeat that again?
So in here, ensuring our long-term strategy for 2024 to 2035, when it's dealing with support our net zero future, how much has been allocated to net zero to deliver on building new foundations?
And I can find that out and provide it to you if the committee wish to have that.
If I could go back to protecting Lough Neagh and the environment, it talks about the SOLS project, so the sustainable utilisation of livestock slurry. Project has facilitated slurry separation in over 70 farms with 6 anaerobic digestion plants using slurry solids. Is them 70 farms all around Lough Neagh?
I don't know where I wouldn't know where they are allocated, but I know that the research and the development is in 1 year into the 4-year project, and they're continuing to deliver the learnings to support some of the to support the sector. But where the farms are, I wouldn't know the locations of them.
So how much money has been invested in Northern Ireland Water, or by Northern Ireland Water, to stop dumping raw sewage into Lough Neagh?
I wouldn't know that, but
is that not part of the Lough Neagh action plan? If it's not, I believe it certainly should be.
Yeah, well, there obviously is, and within the report there's a QR code to go in and get more information on the Lough Neagh report. As far as what I can provide a bit of information is, we know that there's a lot of challenges and that Lough Neagh is not going to be resolved overnight, and that's including the reversing of the damage. There is targeted action being taken, and they are looking at innovative solutions to address the problem and to treat the algae blooms over the longer term. And I think last time we were here, 15 of the 37 actions have been completed, and there's 20 completed now. There's around 2 million has been awarded across 4 suppliers under the Small Business Research Initiative to explore potential solutions and to treat the algae.
Mm-hmm.
So
I think if I could just add to that,
and we're going to finish there.
The TEO role in this is trying to coordinate this and to drive the delivery but we can't be over, one, is not physically possible for ourselves, but two, that would be stepping on the toes of individual ministers who have their own departmental responsibilities. So that makes it difficult us to have all the information, but it's trying to have enough to have a coherent sense of what's going on, and then obviously we can come back with anything else we get from departments.
Okay, very small one.
Small one, and just want to finish off regarding bovine TB, the pilot for transformation. So £4 million has been allocated towards that, which is good because TB is a massive problem and a massive anxiety and burden on many of our family farms. But the key element that's missing from this is a badger cull. So while we have an environmentalist, an environmental fanatic as a minister, he seems to want to run away from that reality if that's what's needed. Happy to eradicate ferrets in Rathlin Island, but it seems to be when it comes to TB, there's more protections for badgers than there is for the unborn. So I believe that won't deliver the tangible benefits that it needs to without a badger cull. Has there been any research done about the benefits of a badger cull here in Northern Ireland?
So we have been talking to the Dara vets last week, and trapping, vaccinating badgers is part of one of the interventions. There's the purpose of this project is to try and do separate interventions that have been tried on their own in different locations at times, is to do them all together. So to do the cattle, the wildlife and the human interventions, bring them all together into one area. It's also supported by shared island funding, so it's going to be a cross-border because we're a single epidemiological unit, is that the word?
Mm-hmm.
And that's the purpose of this. Again, it's a testing and sort of fits well with the transformation fund in that it's letting us try something new that hasn't been done before and putting everything in one place. And then if that works, we can go and roll that out further, because I absolutely agree it's a major issue for farmers and for the whole rural community.
Okay, thank you. Okay, thank you very much for your time today. Really appreciate that. Clark, were there any potential actions for the committee out of that? Please.
First off,
Thank you.
Patrick was going to provide more information in terms of publication of the report on the consultation that Anya asked about. Patrick was going to check and come back in relation to the money to drive down waiting lists as well as capacity building. And information to be provided on net zero and how much was allocated to that. And let me see. Information to be provided on where the farms are located in relation to Loch Ness.
Okay.
That's everything.
Okay, agreed. Okay, moving on then. Written briefing, budget to contingency planning envelope. So just to advise that the department has advised that options are still under consideration by ministers, and they aim to provide a paper to us as a committee as soon as possible. As members will be aware, the executive has not yet agreed a budget 3 years into the financial year, and as a result, TU, like all departments, is currently operating within a contingency allocation. So just going to seek your agreement to write to the department to highlight our concerns regarding the failure to provide the written briefing, and to ask that they provide the outstanding briefing as a matter of urgency. Are we content? Okay, so moving on to correspondence, members. There's not much today, so I'm going to refer you to pages 371 to 374 of your pack for a summary of the correspondence. I'm going to draw your attention to a number of items. 9.6, Committee for Communities, to Head of Civil Service. So just going to refer you to pages 470 to 475 of the pack, and just to advise that the committee has been copied into correspondence from the Committee for the Communities, including a reply from the Commissioner for Children and Young People to the Head of the Civil Service, TU Permanent Secretary and the wider Permanent Secretary group. This relates to the consistency and effectiveness of child rights impact assessments and equality impact assessments. And in Nikki's view, current arrangements do not sufficiently identify nor report the impact of departmental policies on children and young people. So just to remind that we will have an opportunity to consider this matter further during the oral briefing with the Head of the Civil Service. A date in September has been requested, and the committee is awaiting confirmation from Ms Brady, so just ask you to note. 9.7, Secretary of State establishment of the Castlereagh Foundation, and I'm going to refer you to pages 476 to 479 of the pack. Just to advise that the committee has received a response from the Secretary of State to the committee's correspondence of the 28th of May 2026 regarding the establishment of the Castlereagh Foundation. Following the passage of the Identity and Languages Northern Ireland Act, legislative provision was made for the Office of Identity and Cultural Expression, which was created by the Executive to establish the Castlereagh Foundation. Any preparatory work for the establishment of the foundation is for the office itself to undertake, and the UK Government will consider any request for support, including the commencement of relevant provisions in the Act. So just a reminder that the committee wrote to the department to ask that it be kept informed of the timings and commencement of the remaining provisions, and that an update is provided on recruitment within the office once the business plan has been approved and the new chief executive officer has taken up post. And I think there is a slight update there in that Sarah Williams took up post just on Monday there. So just I'm going to seek your agreement to note this item and agree to write to the Office of Identity and Cultural Expression to confirm that they are responsible for taking forward the necessary preparatory work for the establishment of the Castlereagh Foundation, and to outline when this will begin. I'll go for you first, and then I think every had something there.
It's good to get the clarity, and I suppose I would be keen to actually see them come to committee to talk about, you know, the work of Castlereagh Foundation and what work they intend to do in relation to it as well. So I think it would be good maybe to try and invite them. I know time's tight, but it would be good because this is part of now of their work, and with somebody appointed as well, it'll be good to see that work.
Take a note of that. Thank you. Timothy, please, and then
just in support of Deborah, I'd be keen that they do come, but come on a single issue, that we're not bringing or waiting till all the commissioners come, because I think this is an area that we want to focus in on its own. So I very much support that. I think the commissioners, is it next January?
I would say before the end of the mandate. So
either get a written brief or ask them to come along to deal specifically with this item to keep us appraised. I think that'd be a good way forward.
Deputy Chair, do you want to?
Just to confirm.
Confirm. Okay, thank you. Okay, 9.11, Committee for the Administration of Justice, the publication of its third report, and we're going to refer you to pages 498 to 500 of the meeting pack. Just to advise that the committee has received further correspondence from CAJ to our correspondence of the 4th of June 2026 to ask when the third report referenced during their oral evidence session on the 26th of May 2026 regarding activity in URI is expected to be published. CIJ has advised that publication of the report has now been postponed due to the recent disorder across Northern Ireland, and that they remain available to brief the committee following its publication. So just going to seek your agreement to note this item. I'm going to ask the clerk to read other items into the record. Thank you.
Thank you, Chair. Item 9.2 is a Hansard report on the Truth Recovery Independent Panel final report dated 10th of June. Item 9.3 is a pivotal report on suggested reforms to the Northern Ireland Assembly and Executive. Item 9.4, Northern Ireland Fiscal Council's Sustainability Report 2026. Item 9.5 is TEO news release. Junior Ministers launch Head, Shoulders, Knees and Toes Coercive Control Awareness Campaign. Item 9.8 from the Committee for Finance relates to cash profiles and use of vote on account. Item 9.9, again from the Committee for Finance, relates to the April public expenditure outturn and forecast outturn. And item 9.10 is the 69th report of the Examiner of Statutory Rules, and there are no rules relevant to this committee.
Okay, just ask you to note those. Okay, so we're going to move on to draft board work programme. I'm going to ask the Assistant Clerk to talk about any changes. Thanks.
Thank you, Chair. So obviously we don't have the oral briefing with First and Deputy First Minister next week. Just want to confirm that members are happy to request an urgent oral briefing from the Race Relations Unit in terms of the TEO response to the recent disorder in the summer.
Okay.
Or should we ask the Northern Ireland Survivors Council if they could come in to see us? So they're scheduled for the first day back. And I'm just thinking with everything that's going on, it might be an opportune time to...
Sorry, Chair, if you don't mind through yourself. So, Timothy, I liaised with them after we postponed them, and they're not available this date. One of the members of the Survivor Council is out of the country, so that the nearest then date after was the first meeting back for the
well, that answers that. Thank you.
And just then, Raise will present their scope and paper on end of violence against women and girls in terms of any committee inquiry, and then the committee will consider the SL1 for the Ombudsman salary.
Okay, content. Okay, any other business, members? No, I just want to talk about a couple of issues then. So just to advise that I wish to agree a process in relation to FOI requests over the summer recess period. Just to advise that it is standard practice to delegate authority to the chairperson and deputy chairperson during periods of recess to submit views on the releasing or withholding of information in any non-routine or contentious freedom of information requests received by the committee, and that any such views expressed would be brought to the attention of the committee at the first meeting after summer. So just to seek your agreement to delegate authorities to the chair and deputy chair in relation to FOIs should this be necessary. Okay. And just to advise also that the committee will continue to receive correspondence from stakeholders over the summer period. It is standard practice for the committee team to include such items for consideration at the committee's first meeting of the new session in September 26th. I think you said it was the 9th, is that the first meeting?
That's right,
9th
Chair.
of September. And then just to seek your views on whether, if any urgent correspondence is received during the recess paper, they wish to deal with it via correspondence, or if the Chair and Deputy Chair should deal with it on behalf of the committee. So I suppose it's a case-by-case issue then. Are we content
There's
with
any
that?
contentious emails, but we'll not go on.
Okay. All right, any other business, members? No. Okay, date, time, place next meeting, 1st of July at 2 p.m. in this room. The meeting's adjourned. Thank you.
Committee Room 30, sound. Committee Room 30, sound.